Order. The chair recognizes himself for an opening statement. Good morning, everyone. We appreciate y'all being here. Welcome to the subcommittee's budget hearing for the Federal Trade Commission. Unlike last year, this hearing will feature the full slate of all 5 FTC commissioners' testimony. And I want to welcome the 2 newest commissioners, Andrew Ferguson and Melisa Holyoak. Thank you both for serving and being here. I look forward to hearing how you plan to balance out the perspective and representation of the FTC as it protects consumers. Unfortunately, up until this year, the Commission has lost its balanced approach, in my opinion. Since being confirmed over 3 years ago, Chair Khan has taken an aggressive stance towards the use of its authorities, leading to internal discord. Employee staff morale fell from 83% in 2020 down to 53% last year. I'm afraid it has lost its roots as a well-respected bipartisan law enforcement agency focused on protecting against bad actors. Despite restraints on statutory authority, the FTC has plowed forward out of bounds with sweeping new rulemakings, attempting to create policy in the process. Most notably, the Commission's commercial surveillance and data security proposed rulemaking is an overreach, in my opinion, and raises significant legal concerns. I was hopeful that today could be a new start, but I worried that releasing actions of the Commission less than 2 hours before this hearing commences is not a positive sign for transparency of the work you are engaged in. For instance, on pharmacy benefit managers, there's no way for either side of the dais here to analyze the interim report announced this morning. Moreover, have a broader view on whether this means the Biden administration has failed to address this issue broadly at HHS. Commissioners Holyoak said it best, and I quote, "Creating new law is the job of Congress, not the Federal Trade Commission." Yet many of these proposed rules generously interpret existing statutory authorities in the broadest terms, excuse me. This goes beyond the clear directives that Congress has provided. Chair Khan, I fear that your approach can cause severe damage to innovators who have become afraid of arbitrary and punitive actions by the FTC. These efforts, which erode public trust in the Commission, have not been successful in the courts. I want to reiterate what I made very clear in last year's budget hearing. The existing charge and mission of the FTC is too important and must be prioritized. Every day, scam artists take advantage of seniors, children, and other unsuspecting Americans, defrauding them of billions of dollars. I want to ensure that the Commission is effectively using its existing authority to go after and hold these bad actors accountable, protecting Americans from deception and fraud. Nonetheless, the committee has been hard at work on a bipartisan basis to provide new proportionate authorities for the Commission. This includes the Protecting Americans' Data from Foreign Adversaries Act, as well as other bipartisan efforts like the Informing Consumers About Smart Devices Act and the No Hidden Fees on Extra Expenses for Stays Act and the Ticket Act. We've been very busy doing great bipartisan work. We are actively working towards bipartisan agreements, as I said, on the American Privacy Rights Act to ensure we are providing one national privacy standard and protecting Americans' data from being manipulated and abused without their consent, and the Kids Online Safety Act to safeguard our children from the online harms of big tech. I assure you this subcommittee will continue to work together to support and protect consumers from harmful and deceptive practices. But in the process, you must regain our trust by ensuring any authority we provide will not be stretched or contorted to reach your desired result. I implore the Chair to work with all the commissioners, protect consumers from real bad actors, and be faithful stewards of the law. I look forward to conducting this critical and necessary oversight and to hearing each of your testimonies. With that, I thank the Commission, the entire Commission, for being here, and now yield back the balance of my time. And now I will recognize Ms. Dingell from the great state of Michigan. She is the acting chair, or excuse me, acting ranking member of the committee today, the full committee, even though we have a subcommittee today. Mrs. Schakowsky is on her way. So we'll recognize Ms. Dingell first for your 5 minutes opening statement. Thank you.
Thank you, Mr. Chair. I know I look like Frank Pallone. The ranking member asked if I would give opening remarks for him. So we want to start by thanking Chair Khan and the other commissioners for being here today. And I always like being here with my Republican colleagues. We don't always agree, but we work together. The Federal Trade Commission fights unfair, deceptive, and anti-competitive conduct across the entire economy. Under Chair Khan's leadership, it has taken on some of the largest companies in the world, including Amazon, Facebook, and Google, on behalf of American consumers, workers, and small businesses. Since commissioners last testified before this committee, the FTC has finalized a rule banning non-compete agreements, proposed a rule to ban junk fees economy-wide, and exposed collusion between some of the world's largest oil and gas companies. It has also fought back against pharmaceutical companies' illegal hold on drug patents and ordered data brokers to stop selling American geolocation data. I want to commend the commissioners and their staff for this incredible work, especially in the face of attacks from Republicans who would like to see the FTC hobbled and ineffective. I know Republicans don't like how the FTC fights to ensure a fair economy that will grow the middle class and protect consumers from corporate greed. What concerns me is that House Republicans are seeking to cut the legs out from under the FTC through extreme budget cuts. The Republicans' fiscal year 2025 appropriations bill would slash the FTC's budget by almost $40 million. It would also prohibit the FTC from finalizing or enforcing rules like the Combating Auto Retail Scams rule, which bans certain junk fees, material misrepresentations, and omissions of key information that cost consumers when they are purchasing a car. The Commission has estimated this rule alone would save consumers $3.4 billion and 72 million hours of time spent on car shopping each year. In addition to repealing pro-consumer rules, the Republican budget cuts will hamper the FTC's ongoing work to protect Americans from scams, privacy violations, and corporate greed. And Republicans want to go much further with Trump's Project 2025 plan, which will eliminate expert agencies, gut the civil service, and consolidate power under the president. I don't care who's president, Republican or Democrat. That is not a system of checks and balances. This would have a devastating impact on the federal government's ability to protect consumers in the future. The FTC is facing coordinated attacks from big tech and Republicans in Congress. For example, an FTC investigation found that when Elon Musk took over Twitter, he directed employees to take actions that would violate a privacy and data security consent decree between the company and the FTC. The Republican response to that investigation was to attack Chairman Khan and intimidate the FTC staff in an attempt to protect X and its CEO. These attacks, however, have not stopped the FTC from fulfilling its mandate to protect consumers' personal information and ensure that companies are safeguarding Americans' data, something all of us should be able to agree on. The FTC has also taken historic action against data brokers hiding in the shadows while collecting and selling Americans' geolocation data. It's also acted against large brick-and-mortar companies like Rite Aid, which has used faulty facial recognition software to falsely identify people of color as shoplifters. The FTC is also working to reduce the number of unwanted robocalls that we are all sick of, that afflict millions of Americans each year. Over the years, the FTC has filed 170 enforcement actions against more than 560 companies and 440 individuals alleged to have placed billions of unwanted robocalls. And as a result, the Commission has collected nearly $400 million in civil penalties and equitable monetary relief for these violations. The FTC does all this work with fewer employees than it had 45 years ago when the American economy was smaller and simpler. In addition to assuring the FTC is properly staffed, we must restore the FTC's full legal authority that was struck down by conservatives on the Supreme Court. Last Congress's subcommittee led legislation that passed the House that would restore FTC's authority to go to court to force scammers to return money to the consumers they harm. Unfortunately, the legislation never passed the Senate. We must continue to work to restore this authority. We must also work to ensure the FTC has the authority to independently seek civil penalties against rule and order violations. Again, I want to commend Chairman Khan, the other commissioners, and the staff of the FTC for the work they do each and every day to protect American consumers. And with that, I yield back the balance of my time.
Thank you. I thank the gentlelady. And now I'll recognize the Vice Chairman of the full committee, Mr. Armstrong, to give the statement on behalf of Mrs. Rogers, the Chair of the full committee. You're recognized for 5 minutes.
Thank you, Chair Bilirakis, for your leadership. And again, I am giving the statement on behalf of Chair Rogers. Chair Khan, we appreciate your testifying today, along with Commissioners Slaughter and Bedoya, and welcome to the newest additions to the Commission, Commissioners Holyoak and Ferguson. We appreciate all of you being here today and for your service. Chair Khan, the last time you were here, I expressed my serious reservations over the court cases you have lost and some of the priorities you have unilaterally undertaken without clear review and purpose. I know you and the FTC staff have a tough job. With what we have seen from big tech during my time on this committee, I certainly have my own concerns over how they abuse their power and how best to hold them accountable in order to protect Americans. I continue to be concerned that the FTC's court losses are degrading the agency's effectiveness at a critical time when we are trying to modernize the Commission's authority to better protect Americans online, something that will be a fixture of the FTC long after the tenure of you or your fellow commissioners. The challenges we're working to address need strong bipartisan collaboration and consensus. That has always been my goal with Ranking Member Pallone, and it should be the goal of the FTC as well. The FTC also must live up to its tradition of remaining independent from political influence. Under this administration, we have seen time and again the FTC echoing the talking points of the White House. Just last week, we saw President Biden blame higher costs for consumers on price gouging by companies, ignoring how his own policies have caused out-of-control inflation, leading to the high costs across the board. Meanwhile, this subcommittee has been leading on several bipartisan solutions to address the root causes of increased costs by strengthening American supply chains and easing the barriers facing American businesses. More can and must be done, and we need the FTC to foster an environment that both protects consumers and allows businesses to grow and innovate. Eliminating guardrails designed to prevent government overreach, like your removal of a long-standing phrase in the FTC mission statement, without unduly burdening legitimate business activity, are violating due process laws and the intimidation of business. Go against the FTC's core mission as directed by Congress. Chair Khan, the last time you appeared before us, I asked you to convince us that the FTC's core mission, to protect Americans, was not taking a backseat to the Biden administration's radical agenda. You were unable to do so. I still remain committed to establishing the FTC as the preeminent data protection agency in the world, at the direction of Congress. But before that can happen, critical guardrails must be established to prevent the agency from further abusing its power and making sure it's transparent and accountable to the American people. The FTC plays a critical role in protecting Americans, here at home and threats from abroad. As you know, over a year ago, I laid out the case directly to the CEO of TikTok for the harms that his company perpetrated against our national security, American liberties, and the privacy and online safety of our kids. Had comprehensive data privacy and security legislation been in place, you would have had the tools to enforce against TikTok and other big tech for violating Americans' privacy rights. These are goals that I know we share, and I hope that we can work together to achieve them. Thank you, and I yield back.
Thank the gentleman for giving his statement on behalf of Mrs. Rogers. We appreciate it very much. Now I recognize the ranking member of the subcommittee, Ms. Schakowsky, from the great state of Illinois, for her 5 minutes.
Thank you,
You're
Mr.
recognized.
Chairman, and I apologize so much for being late. I think I have quite a different view from my colleague, and he is my colleague, Mr. Armstrong, about the role of the Federal Trade Commission, and I am happy to see all of you, that the 5 of you are here, that we finally have a full array of all the commissioners, and I thank you all for being here. I think that the Federal Trade Commission fights higher than its weight, and I appreciate that, and I appreciate the work that all of you are doing to help consumers get the protection, and small businesses, the protections that they need, that we need. And I just want to say that with only 1,300 employees, that the Federal Trade Commission has been able to return $14 for every $1 that it costs taxpayers. So you do a pretty good job and bring in the money that we need to. And in particular, I mean, there's a whole list of things that the Federal Trade Commission has done that's been very important for consumers, that returned over $280 million back to Americans in FY 2013. That what we see is that it is making rules that will make sure that, let's see, let me make sure I do.
Non-competes?
Oh, well, actually banned some non-competes so that more people would be able to work and get the money that they deserve to make, but also, this is,
Junk fees. Junk fees.
oh, yeah, and you have absolutely done great work on junk fees and protecting data privacy. This is also an issue of the Federal Trade Commission. We have seen lower costs for inhalers and EpiPens. That's a work of the Federal Trade Commission. So on and on it goes, and I really appreciate taking on the things that every single day consumers and all of the small businesses are really needing to go after scammers, which has been such an important thing. So I look forward to your testimony. I look forward to asking some questions, some specific questions about what the FTC is looking in the future to do, and the leadership that you want to take, that the consumers really need. So with that, I want to yield back my time.
I appreciate it very much. I thank the gentlelady.
Oh, can I mention
Yes,
one
please.
more
You're
thing?
recognized. You're recognized. You have plenty of time, yeah.
Yeah, what's our bill? What's our bill? The bill.
Is that the Ticket Act?
Yeah, okay, the Ticket Act. We got that passed in the Congress, and I am hoping that the Federal Trade Commission supports this effort to make sure that the overpricing that we are seeing for consumers is taken under control. I mean, we are so proud, both our chair, that we were able to get that legislation passed in the House, but I think the Federal Trade Commission may have that the hidden fees are dealt with. So thank you. I'm going to yield back for sure this time.
I appreciate it, no problem. And, let's hope that the Senate will take up our bill and get it done, because I think it belongs in the legislative process. So, in any case, thank you very much. Our witnesses today are the 5 commissioners of the Federal Trade Commission. Our first witness is Andrew Ferguson. The Commissioner, you're recognized, sir, for 5 minutes. Thanks for being here.
Chairman Bilirakis, Ranking Member Schakowsky, and members of the subcommittee, thank you for the opportunity to discuss the important work of the Federal Trade Commission. The Commission serves a critical role in the American economy. It ensures that the free enterprise system works for everyone, not just the rich and powerful, by enforcing our competition laws and protecting consumers from fraud and unfair practices. What I've learned in my brief 3 months at the Commission is that our most valuable asset and our most important tool in fulfilling our important mission is our people. Our lawyers, economists, and professional staffers are the lifeblood of the agency. They are consummate professionals dedicated to the vigorous enforcement of our competition and consumer protection laws, protecting our free enterprise system. Every win the agency claims on behalf of the American people is ultimately a victory won by the hardworking staff. The vast majority of our work is bipartisan and unanimous. I've joined my fellow commissioners in supporting a number of important competition and consumer protection matters, and I think the agency is at its best when we work together. But I'm not naive, and I recognize that Congress has created a commission run by both Democrats and Republicans, and we will not always agree. I have not hesitated to oppose my colleagues when I believe they're leading the commission in the wrong direction. That is particularly true for rulemaking. The Supreme Court has been steadily clawing back the power of the administrative state over the last decade. It recently discarded the Chevron doctrine that required courts to defer to agency regulations. But the Commission is going in the opposite direction, undertaking a rash of major rulemakings in the last 18 months, including the non-compete clause rule. I dissented from that rule, and it has since been preliminarily enjoined by the U.S. District Court for the Northern District of Texas. I will continue to speak out when I think the Commission has overreached its authority. The Commission confronts many important challenges. For example, the last time I testified before Congress, I told the Senate that confronting big tech is the fundamental competition question of our day. This is even more true today than it was last year. The Supreme Court has recently expressed skepticism about state efforts to regulate big tech. And Section 230 of the Communications Decency Act forecloses many of the efforts of private parties and state officials to provide much-needed accountability. Antitrust and consumer protection laws are therefore one of the last available avenues to address the many challenges posed by big tech. For example, I agree with my friend Commissioner Holyoak that the Commission should examine whether social media platforms were knowingly violating their terms of service when they deplatformed customers in 2020. And although it lies outside of the FTC's jurisdiction, the practice of debanking by large U.S. banks cries out for regulatory and congressional scrutiny for the same reasons. Similarly, the House Judiciary Committee recently released a report describing alleged collusion among large asset management firms intended to drive up the price of fossil fuels in order to meet emissions targets set by those firms. At least some European countries are becoming more permissive than the United States regarding exemptions for anti-competitive behavior, so long as that behavior has some connection to environmental goals. In America, we have rightfully rejected excusing anti-competitive behavior to further other social goals. Plainly, anti-competitive conduct in the form of horizontal restraints of trade, agreements between competitors to drive down output or to drive up prices, is illegal no matter the reason for it. The collusion alleged by the Judiciary Committee similarly should be the subject of scrutiny by the Commission. We cannot confront these challenges without the ability to retain our talented staff and to hire more like them. As the Congress weighs how to fund the Commission, I hope it will keep in mind the importance of the Commission's mission in protecting the American economy from monopolists and fraudsters, and that we cannot fulfill that mission without our hardworking and devoted staff. I look forward to your questions.
I thank the Commissioner. I appreciate that. Our next witness is Rebecca Slaughter, Commissioner, you're recognized for your 5 minutes. Welcome.
Thank you, Chairman Bilirakis, Ranking Member Schakowsky, and subcommittee members. I'm really grateful for your invitation to testify today about the vital work of the FTC and how we carefully budget the appropriations you provide in support of that work. We last appeared before this subcommittee, as you recognize, Mr. Chair, about 15 months ago. And I want to begin by acknowledging a small but essential set of new expenditures that arose in that time: the salaries of Commissioners Holyoak and Ferguson and their staffs. I'm really thrilled that the FTC has been restored to full strength with the addition of my Republican friends. The FTC delivers best for the American people when our work benefits from different perspectives and ideas, and even disagreement. We've already found many areas of common ground, as Commissioner Ferguson said, and some areas of dispute. But wherever we end up on a given matter, I know the outcome is better because of the rigor, wisdom, and care that our two newest colleagues bring to bear. Turning to the subject of today's hearing, I want to discuss an area of vigorous agreement among all 5 of us. Again, as Commissioner Ferguson just said, the FTC's brilliant and dedicated staff are the lifeblood of our work. Their expertise allows us to understand complex markets when evaluating mergers under tight timelines. Their creativity enables us to continue to deliver redress to your constituents who got scammed 3 years after the Supreme Court took away our best tool for doing so. Their technical sophistication helps us tackle novel challenges, such as those posed by AI. And their commitment means that they do this work often on nights and weekends, and always at salaries far less than they would command in the private sector. I foreground our staff's tremendous value at the outset of a budget conversation because personnel account for the supermajority of our expenditures. Generally speaking, when Congress increases appropriations to the FTC, we hire staff and put them to work, whether stopping robocalls or protecting kids online or advancing the right to repair. Likewise, if Congress were to cut appropriations, we would have to consider furloughs or reductions in force and pass up important investigations and enforcement matters. 15 months ago, my message to you is one of sincere appreciation. Congress had invested substantial new appropriations in the FTC. So let me say again, thank you. I work hard and our staff works hard to use those resources efficiently. Returning money wrongfully taken from the American people is only part of what we do, but we do an astounding amount of it, delivering redress in each of the last 5 years of between $324 and $483 million. But the FTC's value can be measured not only in the money we return, but also in the harm we prevent when we halt and deter illegal conduct. I know that you and so many of your colleagues recognize that value. We regularly receive letters from members of Congress asking us to investigate consumer protection and competition practices of all types across the economy. My message to you today is to please stay the course. Let me sketch out 2 scenarios. In one, imagine that our 2025 funding level is a 1% bump over 2024. In the other, imagine that our 2025 funding level is a 10% cut from 2024. The first scenario, with a 1% bump, does not put the FTC on a primrose path. Far from it. The reality is that a 1% bump and far more would be consumed by rising payroll costs, even with limited hiring and some attrition. In this scenario, we will likely cut back on some enforcement actions that require expert witnesses. I do not want to mince words. Some illegal deals and conduct would proceed unchallenged, and our ability to fulfill our mission would be constrained. In the other scenario, in which our 2025 funding levels are a 10% cut from 2024, the impacts would be nothing short of dire. As you know, the FSGG subcommittee received an allocation for 2025 that is 10% less than 2024, and the full appropriations committee recently voted to cut the FTC's appropriations by 9%, or $37 million. Under this scenario, our mission will be imperiled. We may have to furlough large cohorts of our staff. We will be unable to make necessary investments in IT infrastructure. Mergers we cannot afford to challenge will result in higher prices and less choice. Fraud will multiply unchecked. And we certainly will not be able to tackle the additional work that members of Congress regularly suggest. You may know that the word decimate comes from the ancient Roman practice of killing 1 in every 10 soldiers after a loss in battle. Our staff have been working so hard for the American people, and they win far more tough battles than they lose. Please, please do not imperil our mission and the Americans we all serve by decimating the FTC. I implore you instead to stay the course. I thank you and look forward to your suggestions.
Thank you, Commissioner Slaughter. We appreciate it very much. Now, our next witness is Chair Lina M, Chair of the FTC, and you're recognized, ma'am, for your 5 minutes of testimony.
Great, thank you so much, Chair Bilirakis, Ranking Member Schakowsky, and members of the subcommittee. Thank you for inviting me to testify today. I'm glad to appear here alongside my 4 fellow commissioners, including Commissioner Holyoak and Commissioner Ferguson. We welcomed them to the FTC just a few months ago, and their thoughtful engagement is already enriching the Commission's work. I'm happy to share with you some of the critical work that the FTC has advanced this past year, and to discuss with you the Commission's budget request for fiscal year 2025. Our North Star at the FTC is fulfilling the important mandate that Congress gave us to check unfair methods of competition and unfair or deceptive practices. At its best, the FTC's work ensures that Americans can enjoy the opportunity and freedom that fair and honest and competitive markets provide. Our agency is small but mighty. For every $1 the FTC receives in funding, we provide $14 in benefits to the public. For the American people, there is no doubt that resourcing the FTC is an excellent return on investment. Of course, none of this work would be possible without the talented and dedicated staff of the FTC, whose hard work and fidelity to the FTC's mission protect Americans' pocketbooks, their privacy, and their economic liberty. As American families continue to struggle with higher prices for daily necessities, the FTC's work helps ensure that Americans can keep more of their paychecks. By preventing unlawful business practices, our work improves families' bottom lines and lowers costs, be it at the grocery store, at the pharmacy counter, or the gas pump. No American should pay higher prices because of illegal business practices. Accordingly, the FTC is taking on some of the most widespread consumer frauds and pain points. We are using all of our tools to protect Americans from hidden, deceptive junk fees that cheat them out of tens of billions of dollars a year. We are taking on auto dealers that trick or take advantage of Americans buying a vehicle, one of the biggest purchases that people make. We proposed a click-to-cancel rule that would make it as easy to cancel a subscription as it is to sign up for one, freeing people from subscription traps that can leave them paying hundreds of dollars for services they no longer want. And we finalized a rule to protect Americans from government and business impersonation scams, which are becoming ever more sophisticated with the adoption of AI. We also initiated the largest crackdown on illegal telemarketing in FTC history, working with all 50 state attorneys general to target those who distributed or facilitated billions of illegal calls. We recognize that there is much more work to be done, and as AI turbocharges scams, we're focusing on shutting down fraud affecting older Americans, veterans, and other underserved populations. The Commission is bringing all of its tools to bear to protect Americans' privacy. As Chair McMorris-Rogers recently said, quote, "At its core, the massive commercial surveillance of data is fueling the problem. Nearly every data point imaginable is being collected on us with no accountability," end quote. Against this backdrop, the FTC is harnessing the full suite of its tools and authorities to protect the American public from unlawful tracking and misuse of their data. Over the last year, we have taken on unscrupulous data brokers and secured bans on firms who exploit or endanger people's sensitive health or geolocation data, including by sharing it with entities in China. We've pursued major enforcement actions against companies that endanger kids' privacy by unlawfully hoarding their data or exposing them to harassment online, and we are securing effective relief, banning companies from using facial surveillance tools they've recklessly misused and requiring them to use settings that protect kids by default. No doubt, threats to Americans' privacy and security continue to loom, and I was grateful for this committee's work getting a law passed that will prohibit data brokers from selling American sensitive data to foreign adversaries and charging the FTC with enforcement. I also hope this committee can continue its important work to guarantee strong privacy protections for all Americans, especially as AI tools further incentivize firms to vacuum up people's data, magnifying the privacy risks that people already face. Ensuring an effective FTC requires adequately resourcing it. Thanks to increased funding from Congress these past few years, we have been able to invest in our technological skills and IT infrastructure so that we can continue to keep pace with continued digitization across the economy. I was pleased that last year we launched a new Office of Technology and have been steadily recruiting great expertise to balance out the already talented staff we have at the agency. Ensuring the FTC can continue its good will require further support from Congress. In short, the FTC is firing on all cylinders to protect the American people. Unfortunately, the House has proposed a steep budget cut for the FTC for this upcoming year, and as my colleague Commissioner Slaughter just laid out, the consequences of this would be dire. Thank you so much to the committee for your support of the FTC's mission, and I look forward to your questions.
Thank you, Chair Collin. Appreciate it very much. Our next witness is Alvaro Bedoya. Commissioner, you're recognized for 5 minutes, your 5 minutes of testimony. Thank you for being here.
Thank you. Thank you, Ranking Member Schakowsky, members of the subcommittee. Before I start, I want to note I'm speaking just for myself, and when I talk about corporate conduct, I'm talking about allegations from FTC charging documents. I think a lot of people don't realize that the FTC is actually a relatively small agency with a very broad mandate. So to give you a sense of how far a dollar goes at FTC, I'd love to describe just 1 month in the life of our agency. And I'd love to start in mid-December when we had a case involving Pompe disease, which some of you may know is a debilitating genetic disease which can kill a child in its first year of life. Just one company has a monopoly on treatment for this disease. It charges a family hundreds of thousands of dollars for 1 year of treatment. When that monopolist found out a new company was developing new treatments, it tried to lock down those treatments through an exclusive license. On December 12th, FTC staff sued, and 2 days later, they stopped that. 3 days after that, we stopped an anti-competitive hospital merger in the I-680 corridor of California. 3 hospitals competed there. 2 were more expensive. Those 2 were owned by one company. Those 2 more expensive hospitals tried to buy the 3rd, less expensive hospital. FTC staff sued, and the merger was dropped. That same day, December 15th, we had a big decision on cancer tests. Cancer, unfortunately, is usually discovered after symptoms occur, and unfortunately, that's often too late. So right now, lots of companies are racing to develop tests that will detect cancer in the asymptomatic, before symptoms show up. But just one company has the ability to actually run those tests in its platform. And so that platform company went out and bought one of those test companies in what FTC staff alleged was an effort to corner the whole market. FTC sued, and on that day, December 15th, the court agreed with the FTC, and soon thereafter, the company announced plans to unwind that purchase. 3 days after that, we announced new merger guidelines. It's been clear since 1890 that competition law should make sure that companies compete for labor. They should compete on the pay they offer workers, on the benefits they offer workers. Yet in well over a century, only one merger has been stopped because of how it would affect labor markets and labor competition. So FTC and DOJ issued new guidelines to help law enforcers find and stop those mergers. The next day, we announced a major case on algorithmic fairness. There was a retailer that was trying to spot shoplifters by scanning the face of every single person who walked in that retail store. Only problem was the algorithm did not work. Thousands of times, it identified completely innocent people as shoplifters. They were stopped, they were searched, they were accused, they were detained. This even happened to an 11-year-old girl. So FTC staff sued and stopped that. The day after that, we proposed updates to our children's privacy rules to address changes in how kids are taught in schools, voice-enabled technology, the nudges they receive online. Then after that, it was Christmas, but in between Christmas and New Year's, right in that period, a federal judge granted the FTC's petition to preliminarily enjoin a merger that would have let a company corner a market on healthcare ad technology. A few days after the new year, they dropped that. 4 days after that, we turned to medical privacy. There was a company that was actually tracking people when they went to the cardiologist, the endocrinologist, the gastroenterologist, bundling up that data and using it to sell for advertising. So FTC staff sued, and we stopped that. Finally, 3 days after that, we had a major win on crop control products, on pesticides. These are major line items for farmers. And so ensuring them access to cheaper generics is really, really important. But two of the biggest pesticide brands were actually paying money to block the sale of those cheaper generics to farmers. So FTC sued alongside 10 attorneys general, bipartisan group, and on January 12th, the federal judge blocked an effort by those two companies to stop our lawsuit. Mr. Chairman, Ranking Member Schakowsky, members of the subcommittee, in a single month, FTC staff worked to keep healthcare accessible, affordable, effective, private. They work to keep our kids safe online. They work to make sure that algorithms don't hurt people and that companies compete for our labor. And they work to protect the American farmer, to try to keep those farmers in the black. And this is just what's public, and these are just the highlights. I respectfully urge you to continue what you're doing, which is strongly supporting the people and the work of the FTC. Thank you.
I thank the gentleman, appreciate it. Now I'll recognize and welcome to the commission, Ms. Holyoak. You're recognized for 5 minutes. Thank you.
On already? Oh, okay. Thank you, Chairman, I appreciate that. And thank you, Ranking Member.
Oh. The light doesn't turn on.
Doesn't turn on. Now, here we go. Okay. Thank you, Chairman. Thank you, Ranking Member Schakowsky and members of the subcommittee. Thank you for the opportunity to appear before you today, and I am grateful to be here, and I welcome this hearing. Congressional oversight is vital. The Federal Trade Commission's authority comes from Congress. Among the many critical powers vested in Congress is its authority to set the funding level for the Commission. Our Constitution forces agencies like the Federal Trade Commission to regularly come to Congress and demonstrate why their budget requests are warranted. So it is right that Congress consider the agency's stewardship of what's been entrusted to it. Your oversight helps ensure our faithful execution of the law. I'll note at the outset that since being confirmed in March, I have been fortunate in getting to know and work with a number of the public servants at the Commission. Career staff at the agency make important contributions every day, both here in Washington and in the Commission's regional offices. These women and men enable us, as commissioners, to do our jobs, and ultimately, staff's hard work benefits the American people. A significant part of staff's most important work goes on behind the scenes and takes the form of investigations. These investigative efforts lay the groundwork for public enforcement actions and enable the Commission to bring lawsuits against wrongdoers. In my opinion, the agency is at its best when it robustly enforces the law and does so consistently with the authorities Congress has given us. Since being confirmed, I have voted on a number of these enforcement matters. I would like to highlight just a few examples of the Commission's activities in this area. In April, I voted for the Commission to file a complaint against a bill payment company and two of its co-founders. The Commission alleged that the company used misleading advertising to impersonate legitimate billers. These deceptive practices misled consumers, and thousands of consumers complained about this company's deceptive practices. The Commission alleged violations of Section 5 of the FTC Act, the Gramm-Leach-Bliley Act, and the Restore Online Shoppers Confidence Act. I also voted for filing a complaint against a payment facilitator and two of its executives. The Commission alleged that the defendants knowingly processed payments for deceptive and fraudulent merchants in violation of Section 5 of the FTC Act and the telemarketing sales rule. The defendant agreed to settle on terms requiring the return of $10 million for refunds to consumers and not processing payments for certain high-risk companies. I'm grateful for the opportunity to have participated in these and other important enforcement efforts. As a general matter, I believe the Commission is at its best when it focuses on enforcing the law, not writing it. Creating new laws, as Chairman mentioned, is the job of Congress, not the Federal Trade Commission. With that said, I'm not reflexively opposed to rulemaking where Congress has delegated the agency such authority. Accordingly, since arriving at the agency, I voted to amend or update several rules, such as the eyeglass rule. When engaged in rulemaking, though, the Commission should recall that Article 1 of the Constitution vests legislative powers in Congress, not with agencies. Congress, therefore, sets the requirements and boundaries the Commission must follow. We should never act inconsistently with the authority Congress has entrusted to us.
Likewise, any rulemaking should rest on the sound economic and factual analysis that the law and good policy development require. Finally, I'll flag one other matter that is of great concern to me. As I've suggested recently, one of our country's most pressing issues is the relationship between large technology companies and individual liberty. The concern is one that should go beyond party politics, and I believe the FTC has more work to do on this front. My concern about large corporations and individual liberty has consumer protection implications. For example, when technology or financial services companies use ambiguous or unclear terms of service to shield assessments of consumer conduct in ways that are inconsistent with consumers' reasonable expectations, and sometimes in response to political or other pressure unrelated to traditional market constraints, those companies may violate the law. And when platforms take steps based on their terms of service, that can have significant ramifications. Put bluntly, denying access to financial services or deplatforming can reduce these consumers to second-class citizens. In an era when cancel culture is rampant, including in corporate America, such concerns are far from hypothetical. To the extent we at the Commission can wield our existing enforcement authorities to combat some of these problems, we should do so aggressively. I also believe the Commission should seek to better understand the role that platforms play in controlling and denying access to the digital commons. The Commission should use its 6B authority to better understand how platforms enforce relevant contract terms and how the enforcement of those terms affects consumers. I again thank you for the invitation to appear, and I'm happy to answer any questions you have.
I thank you very much for your testimony, and I'll begin the questioning and recognize myself for 5 minutes. Chair Khan, welcome back. As you know, the third branch of government spoke once again on how government agencies should be conducting their work. On June 28th, the Supreme Court, as you know, in its decision on Loper Bright Enterprises versus Raimondo, overruled the 1984 decision in Chevron versus Natural Resources Defense Council and a 6-3 majority. This will certainly impact the FTC's authority and how it enforces its regulations currently on the books and how it issues new rules. Can you explain how this will now frame your work going forward, please?
Thanks, Congressman. So at the FTC, we've been following closely a lot of the developments across the courts, including at the Supreme Court, where, as you just noted, there have been a set of opinions recently that deeply implicate administrative agencies. And so we've been digesting those opinions and making sure that across the board, our work closely hews to what those rulings say. I'll say a general matter, a core pillar of my approach to the FTC is making sure that we are being faithful to the text of the laws that Congress has written and making sure that we are honoring all of the provisions and not, as unelected bureaucrats, by de facto nullifying authorities or tools that Congress has given us. And so that's really informed my approach to the FTC's enforcement work, and will continue to do that in adherence with all court rulings.
Thank you. Commissioner Slaughter, same question. Can you discuss how this is going to impact how you review rulemakings going forward, please?
Thank you, Mr. Chair. I will associate myself with the chair's remarks. I agree that there's a lot of opinions to digest. We always have to make sure we are faithfully following not only the statutory text, but the court interpretations of those texts. And we will look at them closely and understand how we'll proceed. I will note that as a general matter, much of the rulemaking that we've done at the FTC for decades, since the 1970s, has not been general APA rulemaking. It has been under the specific framework in the Magnuson-Moss Act, which provides both structural guardrails on how we do rulemaking in terms of additional procedural steps, and also substantive guardrails that are really important for us to follow. We cannot, by rule, prescribe or prohibit conduct that would not be prohibited by the FTC Act at all. In fact, by rule, we can only address conduct that is already an unfair or deceptive act or practice and is prevalent in the economy. So those guardrails are really important, and we will continue to apply them faithfully, consistent with Supreme Court precedent.
Okay, Commissioner Ferguson, same question. Thank you very much. Appreciate it, Commissioner. Commissioner Ferguson, you're recognized.
Thank you, Mr. Chairman. I think it's going to discipline agency process across the board. Commissioner Slaughter's right that a lot of our rulemakings are governed by a different statute than the APA, but I think since 1984, and especially over the last 20 years, agencies have relied on Chevron to get away with a lot of stuff that I think they would have a hard time defending if they just had the text of the statute to rely on and couldn't rely on judicial deference. That has come to an end. I think that Loper-Bright is going to sort of discipline internal agency behavior as they come up with their rules, and if it doesn't, the courts of appeals will.
Thank you very much. Commissioner Bedoya, you're recognized. Same question,
Yes,
please.
sir, Mr. Chairman. I'll add to the course you're hearing here. Of course, we have to take into account these decisions, and if it's a different level of deference, obviously our staff and we have to take that into account. At the same time, as my colleagues have said, I'll say that the court didn't overrule our authorities under MAG-MOSSE to issue rules and our mandate to identify prevalent unfair trade practices and make sure the American people are protected from them. And so that process has guardrails. We have to follow them, and that, I think, is what you will see us doing.
Thank you very much. Commissioner Holyoak, again, can you discuss how this is going to impact how you review rulemaking going forward, please?
Yes, thank you. As Commissioner Ferguson said, I think it will discipline the agencies. As I review Loper, I particularly paid attention to something that Justice Gorsuch was talking about in terms of what is required. We need to be looking at statutory text, linguistic context, and the canons of statutory interpretation, and that will be our burden. We have to be prepared to go to court and defend what we are doing, going back to the statute and looking at those, and not just a permissible interpretation of a statute, but the right interpretation. And that's what we will have to do. And I have done that just recently in one of my dissents in the health breach notification rule, relied on statutory canons of interpretation when I showed that the rule was overbroad in with respect to the specific statute at issue.
Thank you very much. I appreciate that. I'd like to remind all the commissioners how important the Consumer Protection Mission is on fraud and deceptive practices, and it is inviting to debate. Again, we talk about the antitrust theory. The single most important thing to me is how consumers are getting ripped off, and they are getting ripped off and scammed by bad actors, especially, I'm concerned about our seniors. I ask you not to lose sight of that. None of you, please don't lose sight of that. It should be a priority. Not divert resources under the assumption that it is best left to state attorneys generals. And I have to yell back because I want to be fair to my ranking member. So I yell back and I recognize the ranking member of the subcommittee, Ms. Schakowsky, for her 5 minutes of questions.
Thank you, Mr. Chairman, and I agree with everything that you said. Let me just say this. I know that some of my colleagues, the Republicans, proposed cuts to your budget, and I'd like to ask you, Chair Khan, what would be the effect of nearly a 9% cut in the budget of the Federal Trade Commission?
Thanks, Congresswoman. I mean, it would be extraordinarily dire. As Commissioner Slaughter laid out, we would be in the very difficult position of most likely having to furlough staff. We would undoubtedly be further shrinking the size of the FTC, and as you know, we are actually 400 people smaller today than we were in the early 1980s, even though the economy has grown 16 times over. And so that would mean that our work across the board would be diminished. And so we're talking about work taking on fraud and scams, including those that are targeted at elderly Americans, as we just heard, at veterans, at underserved communities. It would mean we wouldn't be able to take on made in USA fraud when companies say their products are made in America, but actually they're made elsewhere. It would mean we wouldn't be able to go after as much companies that through law breaking are inflating costs for Americans across the board, be it their healthcare costs, be it how much they're paying for groceries. It would mean that our work protecting Americans from data abuse would suffer. And so across the board, we would be able to do less of the fantastic work that our staff have been doing, and Americans would be more exposed to corporate law breaking. And so, the prospect here is quite dire, and so I really hope that Congress can instead continue to support the FTC's mission and fully resource us.
Thank you for that, and I agree that we need to fight for that. As I mentioned earlier, the chairman and I have been working on some surprise fees on the Ticket Act. But what are you doing? Because this is certainly only one example of what happens with surprise fees. So what is the FTC doing on that?
So we are pursuing action against unfair or deceptive fees, both through our law enforcement work as well as through rulemaking. Just the other month, we pursued a enforcement action against a company that had basically included these deceptive early termination fees. And so when people were signing up for subscriptions, they were not being told clearly that trying to exit the subscription would actually require paying hundreds of dollars. And so we're going to continue to do that enforcement work. We've also proposed a rule that would prohibit junk fees and basically require companies to upfront include in the price all of the mandatory charges rather than saddle people with surprise fees after they're already captive to the process. And so we hear time and time again just what a big pain point this is. That rulemaking is ongoing, but we've already gotten 60,000 comments.
Thank you. Let me ask one more question. In 2001, the Supreme Court said that the FTC did not have to give money back to consumers, which had been in place. And I am just wondering if I could go one by one, from left to right, if you could tell me if you think that there should be a change in, what is the name of it?
13B.
13B, that would allow money to go to consumers. Could I start with you?
Thank you, Madam Ranking Member. Yes, I think AMG was correct, but I think it is super important that Congress restore the authority we thought we had under 13B as soon as possible.
Agree that restoring this authority would be critical for our ability to protect consumers.
Thank you.
Absolutely.
Yes.
I agree.
Thank you. And with that, I'm going to yield back.
Generally yields back. I now recognize myself for 5 minutes. I want to thank Chair Bilirakis for calling today's hearing, and to all the FTC commissioners for being here today. Oversight is a critical part of this committee's job, especially over parts of the government that impact the lives of every American and nearly every industry. With Chevron, Congress needs to aggressively reclaim our authority and stop allowing federal agencies to create laws where they do not exist and force them to follow congressional intent when they do. It's really important. Frankly, honestly, from my perspective, agencies have, and I'm speaking of all agencies, I'm not singling out the FTC, have had minimal accountability to the American people. With Chevron, I think we add some accountability, even though it is in the courts. Since June of 2022, the FTC has been studying the contracting practices of pharmacy benefit managers, PBMs, and their impacts on patients getting access to life-saving drugs they need. I'm in full support of injecting transparency into their operations. In fact, I believe their compensation needs to be decoupled from drug list prices. They do add value, but we need to tighten up the ship. I'm concerned about the market impacts of both consolidation and vertical integration in the PBM market, and find it puzzling that even with all the power PBMs have amassed over the years, they felt the need to create whole new entities called GPOs, or government or group purchasing organizations. As I'm sure you're aware, the Ohio Attorney General recently filed a lawsuit against one of these GPOs and several PBMs, alleging that these entities were engaged in anti-competitive behavior. Very little is known about these GPOs except that they've created new revenue streams for PBMs and insurers that own them. I know that two have been set up offshore in Ireland and Switzerland, and there are indications they did that to take advantage of lower foreign corporate tax rates and privacy laws. Chair Khan, Is this something the FTC is examining?
Thanks for the question, Congressman. And on both fronts, yes, as you noted, the FTC has been scrutinizing the pharmacy benefit managers for a couple of years now. We just released an interim report with some of our staff's initial findings, laying out, as you just noted, the significant vertical and horizontal consolidation, as well as the concerns we've heard from independent pharmacies, for example, as well as the risk of potentially inflated prices. We do 2 case studies in the report, specifically on cancer drugs, showing some potentially troubling outcomes there. On GPOs specifically, we've heard concern from doctors in particular that shortages in areas like antibiotics and chemotherapy may be driven in part by the practices of these GPOs. And so a few months ago, in partnership with the FDA, we launched an RFI to collect comments from the public on these GPOs, and we're continuing to review those comments.
Commissioner Holyoak, you want to comment on that? You have any comment, or anybody else have a comment on that subject?
On that subject, certainly, as you may know, I dissented from this morning from approving this report. I don't believe the report is sufficient. I think it lacks economic and empirical evidence. I think it doesn't look at all of the players in the pharmaceutical field. I think it doesn't doesn't look at all at consumer prices and how consumers are impacted. I'm also concerned that there was a very thorough report from 2005. It doesn't attempt to look at that report and describe the changes from the market conditions from that report. It doesn't explain why those changes exist. I think the 2 case studies are not, we don't know if they're representative of the field. It's too early to know. It's not sufficient. It doesn't provide enough evidence to understand what that actually means. Those 2 case studies also talk about reimbursement rates to the PBM affiliated pharmacies, but don't tie that to actual consumer harm and what's happening with prices. And I think there's a lot of work that needs to be done still on that. And I hope that the commission can commit to doing that work and providing a fulsome report.
Thank you for that. I have a few seconds, so Chair Khan, how did we lose the United Health Group Change Healthcare case?
So that was one.
The government, it may not have been just exclusively you.
Yeah, it was.
Because you see what happened, right? Subsequently, Change Healthcare was hacked because their security wasn't properly evaluated in this process. And so how did we lose?
So this was a Justice Department effort to block that merger.
Right.
Unfortunately, as you noted, they lost in the DC District Court. That was a vertical merger, and the judge ultimately ruled that he didn't think the risks of anti-competitive effects would be resulting, and he thought that some safeguards that the companies had promised they would put in place would be adequate. I do want to just step back and note a broader trend here where we see time and time again, as companies become more dominant, we are seeing how a single data breach or a single hack can have cascading consequences, be it in healthcare, be it for auto dealers. There was just a big hack that rendered auto dealers kind of captive to a single company. So this is a broader trend, and especially for the FTC that oversees both competition and data security, being able to connect the dots here is going to be critical.
Fair enough, and I think in the PBM space and in this type of situation that Congress, in light of Chevron, needs to put some laws in place, potentially, or at least debate them to help us and help you. I now yield back, and I yield to Ms. Dingell. 5 minutes.
Thank you, Mr. Chairman. Privacy should be a fundamental right in this country, and this committee has been diligently working to advance privacy protections. I'm hopeful that this Congress, we can pass a comprehensive federal privacy law. Hope springs eternal. We must focus on ensuring that consumer data collection is minimized and that only necessary data is collected, used, retained, and transferred. Building consumer trust requires robust protections for sensitive data and stringent enforcement mechanisms for when those protections are violated. As vehicles become increasingly connected and capable of collecting vast amounts of data, it is essential to understand the implications and potential privacy risks associated with this technology and its impact on consumers. Recently, my colleague Rupp Castor and I wrote the commission to express concerns around automotive manufacturers' data privacy practices. I appreciate your timely response, and I want to follow up with some questions. And I am going to say again, I think the American people have no idea how much of their privacy is being given away. And until they read in the New York Times that car companies were giving their data to insurance companies and it was hiking up their prices, it wasn't real, it didn't cost them money, and maybe we'll start to see more emphasis on why we need to do something. Chair Khan, can you elaborate on proactive steps to prevent future privacy violations and talk about enforcement mechanisms related to connected vehicles?
So this is an important area of inquiry for us. We read a lot of those reports. We'd separately been hearing a lot of concern about this. And I think for a lot of people, they assume that when you're driving in your car, there's a base level of freedom that you have, right? You're not being surveilled. And I think across the board, people have been waking up to the reality that unfortunately, their precise geolocation is not only being collected and tracked by private companies, but oftentimes is being trafficked, being bought and sold, including to foreign adversaries, to companies across the world. And so this is a major, major issue. At the FTC, we have kind of put market participants on notice about how we would view some of these data sharing and collection practices. We need to make sure at the very least that people are not being deceived. I'm limited in what I can share about any non-public investigations, but I can assure you that we are tracking this closely.
Thank you. Chairman Khan, what measures are being taken to ensure that consumers are fully informed about their data in relation to connected vehicles, third parties, and data brokers?
So if companies were to engage in certain data collection practices that they were not being fully upfront with users about, that could give rise to potential deception violations. More generally, the FTC has been very focused on categories of sensitive data. So that includes health data, it includes geolocation data, and through our enforcement actions, we have made clear that there has to be a presumption against selling this sensitive data. And so if you're collecting somebody's geolocation data, you can't just share it or sell it without getting their affirmative permission. And so that's a principle that would apply across the board, be it an app or a car.
Chair Khan, given the rapid evolution of connected vehicle technology, how does the Commission plan to stay ahead of emerging data privacy challenges and ensure comprehensive protection for consumers?
So we have fantastic experts on board that are studying this closely, that are really looking under the hood to understand what are the precise mechanisms by which some of this data is being collected, how can it be used. We have our law enforcement work ongoing, we have potential rulemakings underway, and so we will faithfully continue to use all of our tools and authorities to make sure that people's sensitive data is protected.
Thank you. I'm going to do a really fast question on total pricing rule and probably do more follow-up. Will you be working on the total pricing rule with the industry-specific regulatory agencies, including the FCC, which is testifying before the Communications and Technology Subcommittee downstairs today to ensure that your rules are harmonized with the rules of other federal agencies? You two run up, FCC and FTC run up against each other.
Yeah, as a general matter, we're always keen to be learning from our sister agencies. We have a great relationship with the FCC. As you know, there are areas where our jurisdictions do not overlap, and so they have oversight over common carriers and other providers that we cannot oversee. But nonetheless, it's always very useful to be learning from one another.
Thank you. I'm going to send more questions for the record on that. And I'm just going to say as I close, I remember sitting with my colleagues on both sides of the aisle several years ago when I was bringing up issues, and someone said, what do? Do you take drugs and think about these things at night? People had no idea that cars are smart cars, just like they are on phones. And that's one of the serious issues facing us. I yield back, Mr. Chair.
Gentlelady yields back. I recognize Mr. Wahlberg, 5 minutes.
Thank you, Mr. Chairman, and to my colleague from Michigan, I never thought whether you took drugs. I wouldn't have suspected that, so. Protecting kids and my colleagues and teens online is a top priority for me and so many others across the country and on this committee. I led COPPA 2.0 along with my friend Representative Castor, which would update and strengthen the Children's Online Privacy Protection Act by expanding protections for teens, prohibiting targeted ads, and establishing clear data minimization requirements. Commissioner Holyoak, welcome. Can you speak to the importance of COPPA in the past and how we can continue to improve online protections for minors?
Absolutely. Thank you for that question. This is an important issue for me. I have 4 kids, and tracking what they do online sometimes feels like a second full-time job. So it's tough. And COPPA is an excellent tool for the commission. Just today, we announced a settlement with a company, and it was a complaint that included a COPPA claim. And this is an app that would send anonymous messages to teens saying things like, "I know what you did. I see you on Instagram." I mean, it's terrible things. There's terrible problems out there, and so it's an important tool for that. And I thank you for your leadership on this. And I think Congress should continue to look at these issues and continue to see if we can find ways to strengthen our enforcement efforts. And if those laws are passed, I will vigorously enforce those.
Yeah, well, we need to work together strongly on that, and I think the time has come. Oh, well past come. Chair Khan, the Northern District of Texas preliminarily enjoined the FTC's non-compete rule, stating that the rule likely exceeds the agency's authority and that it is arbitrary and capricious. Strong words. Assuming this is a final decision of the court, will the FTC stop trying to promulgate this rule?
So as you know, this was a preliminary injunction hearing, and the judge has said that she will issue a full opinion by the end of August, so we will wait to see what happens there. And of course, we would proceed in accordance with court decisions that come down. We're still reviewing and proceeding accordingly. More generally, I mean, non-competes now trap over 30 million American workers, and we've heard from over 25,000 people across the country about how non-competes are keeping them locked into their current job, preventing them from going to get a better opportunity elsewhere. We actually brought a case involving janitors and security guards in Michigan who were making close to minimum wage, who wanted to be able to switch jobs to get a higher wage, and instead they were threatened with lawsuits for tens of thousands of dollars. So we're talking about real harms to real people. As our rulemaking lays out, we think that not only are American workers less free, but our economy is worse off, less dynamic, less competitive.
Well, we'll
and
look forward to
innovation
court
will suffer.
having a final decision on that, and I'm encouraged that you say you will follow that. Commissioner Holyoak, the court's decision largely tracks your dissent. What's your assessment?
Thank you for the question. Yes, my dissent points out that the first and foremost, when we're doing a rule, we need to look and see what is our source of authority. Here, the non-compete relies on both Section 5 of the FTC Act and Section 6 working together. Section 5 is where unfair methods of competition is contained, but Section 5 sets forth a really comprehensive adjudication framework. Section 6, by contrast, sets forth our authorities relating to investigations. And inside Section 6 is a rule, Section 6G, that says that we can classify corporations or make rules in furtherance of the provisions of this act. So that is where the source of authority, the non-compete, claims to have that authority. But the question is, you have to look at the entire text and structure of the act. Does that little provision, that ancillary provision in Section 6G, what kind of rules does that allow? Does it allow procedural rules, internal operating rules, or legislative rules, which is what the non-compete alleges it does? And to understand that, we look at the entire text and structure. Section 5 has absolutely no mention of rulemaking. It talks, again, as I mentioned, adjudication, but not even any sort of adjudication of prescribed rules. So looking at the text and structure together, There is, I believe, and as I explained in my consent, that no reviewing court would find that there was rulemaking authority under Section 6 and Section 5 together for unfair methods of competition. And that is what the court held. The court, as Chair Khan mentioned, is a preliminary injunction, but the standard for a preliminary injunction is likelihood of success on the merits. So that is what the court held.
Thank you. My time has expired. I yield back.
Gentleman yields back. Now recognize Ms. Kelly. 5 minutes.
Thank you, Chair and Ranking Member, for holding this important hearing this morning. I also want to thank the commissioners for their testimony. Artificial intelligence will lead to positive advancements. However, we also know that there are real concerns, especially as fraudsters and scammers are using AI tools to impersonate individuals, causing Americans to lose thousands of dollars. In fact, the FTC estimates that impersonation scams cost consumers more than $1 billion over the course of just last year. We must ensure that Americans are equipped with the necessary information to identify these scams, and our government agencies, like the Federal Trade Commission, have the necessary tools and resources. That is why I recently introduced the Protecting Seniors from Emergency Scams Act, which will help older adults identify scams before it's too late. Similarly, I am pleased that the FTC finalized the government and business impersonation rule, which gives the agency stronger tools to combat scammers who impersonate businesses or government agencies. And I appreciate that you have issued a supplemental notice on prohibiting individual impersonation because of rapid improvements on AI. Chair Khan, may you please discuss the genesis of the government and business impersonation rule and explain how it will help empower the FTC to handle such scams, and also tell us what the next steps are for the individual impersonation rulemaking.
Happy to. So unfortunately, despite vigorous enforcement by the FTC, these types of imposter scams remain quite prevalent. It's actually one of the biggest sources of fraud that we get reported from the public. And so you'll have, for example, somebody pretending to be an IRS agent and call up an unsuspecting victim, tell them that they owe thousands of dollars and risk arrest if they don't pay up. I mean, these are really awful scams that fall on people. And so we proposed a rule that would basically allow us to get money back for people who are defrauded from those scams. It would also unlock civil penalties. And I know there's been a lot of discussion about, should we just do lawsuits? Should we also do rulemaking? These things are actually deeply connected, because after the AMG decision, we are not able to get money back for people who are defrauded by these imposter scams. And so because we've done the rulemaking, now if we allege a rule violation, we will be able to get that money back. We'll also be able to levy civil penalties, which is incredibly important for deterrence. You need to make sure that the scammers can't profit from scamming, and that's what these rules will help us do.
Thanks so much. Commissioner Slaughter, would you like to add anything as it relates to the agency's work on mitigating scams?
Sure. I think it's a really important topic. I would note that in this rulemaking, we had very widespread support from the business community, because businesses suffer when they are impersonated to perpetrate fraud. And so it's an example of a rule that helps us utilize the statutory tools that we have. As Chair Khan said, we have a long enforcement record behind it, and what we had found is that case-by-case enforcement was not sending enough clarity to the markets about what conduct was illegal, and was not putting enough deterrent thumb on the scale to prohibit that conduct. So again, we can't go beyond practices that are unfair or deceptive, so barred by the FTC Act, and we can only address by rule those practices that were prevalent in the economy. And we had to do that after a very extensive, engaged, public participatory record process. But we're really proud of this rule and excited to make sure that we continue to adapt our enforcement efforts to the patterns that we're actually seeing in the marketplace.
Thank you so much. I'm also concerned about the American workforce, largely due to the emergence of AI, but also because industries are still recovering from the COVID pandemic. Simply put, we need to ensure our job market is strong and that both future employees and employers have the necessary resources to find the right fit. For the last couple of decades, as we've all witnessed the emergence of the internet, companies have revolutionized the recruitment industry by making user-generated resumes and professional profiles publicly accessible, creating an invaluable resource for employers and job seekers alike. Yet it is my understanding that companies are now taking aggressive actions to dominate the digital recruiting industry by putting these public professional profiles behind paywalls. I'm concerned that the consumers are seeking jobs and choose the option of making their information public would be surprised to learn that not all would-be employers can view their profiles, and that this move could also reduce competition in the recruitment industry and therefore have a negative impact on hiring activities across the country. Commissioner Khan, is this an issue that you and your staff are aware of, and is it something you can look further into? In 10 seconds. Oh, I'm over already.
As a general matter, we're very aware of how digital markets in particular can tip and result in more dominance and monopolization in ways that can harm competition. Happy to be in touch about the specific issue you raised.
Thank you, and I yield back.
Thank you. Thank you. I appreciate it. Now, Ms. Lesko from the great state of Arizona, you're recognized for your 5 minutes of questioning.
Thank you, Mr. Chair. Chair Khan, how many employees or consultants has the FTC hired from the Open Markets Institute, American Economic Liberties Project, and Capital Forum?
Congresswoman, we've been really fortunate to be able to recruit top talent from across all sorts of workplaces and all sorts of forms of expertise, including private sector, including public sector, including nonprofits.
Do you know the number from those particular organizations that you've hired?
Not off the top, but we're going to look into it.
Well, can you send it to me and the committee, please, once you check into it?
We're happy to look into it and be in touch over writing.
Okay, so you're going to give me the answer, correct?
I don't know if there are kind of HR rules that we would be running afoul of, but assuming we are able to share that information in accordance with agency policy, we'd be happy to be able to share what we can.
Thank you. Chair Khan, I'm hearing that there are significant leaks coming out of the FTC, especially to left-wing news organizations, including Capital Forum and the New York Times. The House Judiciary Report concluded that the FTC's explanation of the leaks was implausible. What have you instructed Commission staff concerning these continued leaks, and has anyone at the FTC leaked stories to the press during your tenure ahead of public announcements?
So I couldn't agree more that ensuring the integrity and security of non-public law enforcement information is absolutely paramount. Before I arrived at the FTC, the Inspector General actually did a survey and identified some vulnerabilities. And so since I've joined, we've been taking steps to put those safeguards in place. Of course, we continue to remind our staff of the importance of maintaining...
Excuse me, just because I'm running out of time. Have you instructed Commission staff concerning these continued leaks? Have you talked to the staff about it?
As a general matter, I believe our general counsel has reminded everybody of the importance of maintaining the security and integrity of law enforcement information.
And do you know personally if anyone at the FTC leaked stories to the press during your tenure?
No, I don't know that.
Okay.
I'll say as a general matter, one pattern we often detect is once we are interviewing third parties as part of our investigation, that ends up being a moment at which some of this information also can become public. So we'll do everything we can to keep non-public information non-public, but sometimes other actors have this information as well.
Thank you. Chair Khan, the national debt is approaching $35 trillion. I believe this year our interest payment on the debt will exceed the entire budget of the Department of Defense. With that in mind, can you provide justification for the 25% increase in the FTC's budget request for fiscal year 25?
Yeah, I'd be happy to. So a significant amount of this would actually cover unfunded pay increases. 70% of our budget goes to covers FTEs, and so when there are 5.2% statutory increases in how much we have to pay, but we're not getting money for that, that really pinches us. In that budget request also is included funding for critical upgrades to our IT infrastructure. as we are doing more of these investigations in AI and looking at monopolies in digital markets, we end up having to analyze a lot of big data, reams and reams of data. And so we need to make sure we actually have the capacity and the infrastructure to do that analysis. Beyond that, there are non-pay related cost increases that we are running up against. And so that's what this would cover as well. But the vast majority, 70%, would cover employees.
And Chair Khan, can you expand on why you would give pay increases if you don't have the budget?
So we can't unilaterally decide to pay employees more. That's something that Congress has done. Congress has, through statute, said these employees need to be given increases in pay, and so we are following what Congress has told us to do. As a general matter, I fully understand being concerned about spending, but I'll just underscore, for every $1 the FTC receives, we return $14 back to the public.
We always talk about the debt, and I'm really concerned about our debt and the amount of interest that is accumulating when it exceeds the Department of Defense budget. That's a national security risk. And so I guess, in my personal budget, if I go over budget, I would probably have to, say, okay, maybe we can't employ as many people and that type of thing. So that we have to start addressing our national budget or everything's going to be a problem. And with that, I yield back.
I tell you what, we're going to miss you, Representative Lesko. That's for sure. Now I'll recognize my colleague from the great state of Florida, Ms. Castor, fellow caller from the Tampa Bay area. You're recognized for your 5 minutes of questioning.
Well, thank you, Chair Bilirakis and Ranking Member Schakowsky, and welcome to our FTC commissioners. Thank you for all that you do, standing up to scam artists and fraudsters. Our neighbors back home really need you. We need the cops on the beat of the FTC rising up against the folks who are trying to deceive our neighbors and use unfair, deceptive trade practices. So I want to associate myself with the remarks of Ranking Member Schakowsky. This is not the time to take the cops off the beat. The scam artists aren't taking a vacation. The fraudsters aren't saying, okay, if you're going to cut the budget, we'll take a vacation. They're not. They're going to double down if we take FTC cops off the beat. So thank you, Ranking Member Schakowsky, for that, and hopefully we can fend off harmful cuts. The last time you all were here, we had a larger discussion on comprehensive data privacy. It's good to see that this hearing is also focused in on how we protect Americans from just the incessant surveillance, tracking, collection of our personal private data, and then the sale of it. Commissioner Holyoak, you framed it as big tech corporations versus individual liberty, and I think when Rep. Dingell talks about the average person does not understand how they are being constantly turned into a product and their personal data is being sold. That example of smart cars gathering the data and that your data being sold to insurance companies does help tell the story. We have been focused, especially I have, on the impact on kids. That's why I introduced the bipartisan COPPA 2.0 with Vice Chair Walberg. COPPA passed more than 2 decades ago, but think about the evolution in technology and the ability of big tech to track and deceive children. And parents just feel like they're over the barrel right now. COPPA 2.0 still has not been marked up in the full committee. But thankfully, the FTC has been undergoing rulemaking under the authority that you currently have to, I understand your proposed rule. It requires opt-in consent for third-party behavioral advertising. It strengthens retention limitations and data minimization requirements. It codifies current guidance on ed tech, strengthens transparency and accountability for safe harbor programs. But Chair Khan, now that the commission has undergone rulemaking and a comment period, can you share some of your findings and what is the outlook?
Well, first, let me just say thank you for your leadership on this key issue, and I couldn't agree more that Kids need to be able to play and learn online without being endlessly tracked and surveilled by companies that are selling their data for profit. We were really glad to be able to propose an update to COPPA that would strengthen the rule in the ways that you mentioned. Our folks have been digesting the thousands of comments that have come in, and so we're not quite ready to kind of share what the final rule will look like, but we're moving forward on this work steadily. We're also continuing with our law enforcement. And so just over the last year, we secured a record-breaking COPPA penalty with Epic Games, which we found had been, collecting data on kids without getting parents' consent. We also brought a case against Amazon's Alexa, which we found had been storing kids' sensitive geolocation and voice data and not allowing parents to delete that data as they're supposed to be able to under COPPA. One principle that we're making clear, as you know, COPPA has a limit on indefinite retention on data. And one thing we are increasingly hearing from companies is that in this age of AI, they have a business reason to endlessly hoard data because they want to continuously refine their model. And so we've made clear, including through that Alexa matter, that there is no AI exemption to the COPPA limitation on indefinite retention. So that's another area where we're continuing to push.
That's good. Commissioner Slaughter, you've been very active and outspoken on this topic. What's your view?
Yeah, I think that's right. We're going to do whatever we can with the tools that we have, but I think this is an area where it's really critically important for Congress to act. COPPA was groundbreaking and revolutionary and changed the landscape, but I think it's past time to update it. We can't do everything that you can do. As we've said a couple of times, we can implement the COPPA law that was passed in the past. We can do new rules that address unfair deceptive acts and practices, but you can go much further than that with clarity and specificity to market. So we stand ready to help and support in those efforts, and we're really grateful for them.
Thank you very much. I yield back.
Gentlelady yields back. Now recognize the next governor from the state of North Dakota, Mr. Armstrong.
I actually had a whole line of questioning on something, but something Ms. Castor just said, I may ask all five of you this question because I think it's fairly important. You just said there's no indefinite retention on AI, and we're not going to exclude that, correct? Chairwoman Khan?
Under COPPA,
Yeah.
so for certain entities in certain contexts.
So my question is once information is generated into AI, how is it not retained permanently?
So you mean basically how can you require unlearning from the model?
Yeah.
Yeah, I think that's a great question. As far as we know, it's not possible, and that's why timely action is incredibly important, and making sure firms are not in the first instance able to use unlawfully collected data to train their AI. It also, your point raises another issue, which is business could face an incentive to actually play fast and loose with the rules because their monetary gain from that and the value they'll generate from training their AI could be so important. And so for all of these reasons, kind of stronger rules of the road are going to be critical.
I'm going to ask the two new commissioners one at a time their thoughts on this, because I think this is the next big conversation. Anybody who's heard me talk about this, whether it's government-related, Fourth Amendment-related, privately related, if you have a 16-year-old daughter and a 14-year-old son, privacy in the 21st century is going to be the conversation we have and how we monetize all of these things. So what tools do you need from us, Ms.?
I mean, well, and to your question on what do you do once that data is captured, it's an interesting question. I'd say, I mean, these emerging technologies, we don't fully understand exactly what they're capable of, but I think what's interesting is I think there'll be more technologies that may help us in terms of fighting some of these issues. The FTC's work on the voice cloning challenge is a great example of where we're concerned about voice cloning, the use of AI, where you have fraudsters calling up grandmas and saying, this is your grandson using a voice clone, and worried about that. So the agency, we just had a voice cloning challenge where we had companies come in and say, what can we do to fight this? And they provided different technologies that could help assess that. And I think the same is possible with these types of issues where you're going to have, we're going to see these types of problems arise in the markets. I think we'll also see solutions arise too. And I think we can let the markets develop and understand where those, with constantly assessing where the markets are, remaining vigilant, using the tools that we have to address the concerns that they have when there are unfair and deceptive trade practices and or if there's competition issues as well.
And I know when we talked, coming in, we talked about the Ticket Act, and one of the things that concerns me about AI is somehow it's the enforcement, right? If you use 5 other songs to create a song, you have to pay royalties for it. We all know if you don't, you get sued, and if you can prove it, you end up losing on a royalty case. There's famous ones. My concern is we don't know the 5 inputs, and there's this fight between open source and non-open source. And so I don't want to live in a world where every musician is created by AI. I don't think you get Nirvana in 1991 off of Motley Crue in 1987. I think AI is pretty smart. I don't think it's smart enough to do that. I also think by the time we get around to regulating it or legislating on it in a meaningful way, the technology is going to be so far past us that there's very few times, and I can say that up here because the Music Modernization Act became law before I got here, and it's actually worked. It's not perfect in the new environment, but it was originally started to be written under Napster and LimeWire and all of those things, and it still exists. But, what different enforcement challenges do you see moving forward in this space, Mr. Ferguson?
So the commission's got its suite of statutes that it enforces, and most of them are relatively old, and they're very old compared to AI. And the stuff that you're talking about involve these massive trade-offs between promoting the innovation. Look, AI will be a super important tool for new challengers to come and challenge big tech incumbency. And we don't want regulators sort of strangling that in the cradle early on. At the same time, tremendous risks are associated with AI. But these are huge political, sort of national economic trade-offs that Congress needs to make afresh. It can't be that the agencies take these statutes from the 1910s and 1930s and tries to sort of fit AI into that system. Congress has to tell us, or whichever agencies they're going to empower to do this enforcing, how to do these trade-offs.
Well, and I think one of the first questions we have to answer, which is really actually hard, is how do we define open source? Open source is very different now than it was 5 years ago. If you can get a song online and feed it into an AI generator, I can't play that song at my business without paying royalties, but once I put it into an AI generator, I don't know. And so I understand the regulatory side of it. I'm very concerned about how we actually, you all do it and we do it, how you actually figure out a mechanism to enforce it. Because stealing something and making something not original your own is, we have the rules in place. We just I don't know if I think we're massively inadequately prepared to enforce it. And with that, I yield back.
Okay. I now recognize Ms. Clark from the state of New York. You're recognized for your 5 minutes of questioning.
Thank you very much, Mr. Chairman, and I thank our ranking member Schakowsky for holding this hearing today. I'd also like to thank our commissioners for being here to testify. In our increasing complex society, the FTC provides clarity for businesses and consumers alike, protecting the American public from deceptive or unfair business practices and methods of competition. Under the leadership of Chair Khan, the FTC has taken important steps to combat unsolicited robocalls, scams turbocharged by AI tools, junk fees, dark patterns, and much, much more. And while I am concerned about our lack of federal data privacy standard and the ability for unchecked automated critical decision-making processes like algorithms to produce biased or discriminatory outcomes, I'm confident that the FTC, once properly empowered by Congress, can rise to meet the challenges presented by rapid advances in artificial intelligence. Though in this Congress we have thus far been unable to move through the full committee comprehensive federal data privacy legislation that appropriately centers algorithmic accountability, the FTC has taken important steps to addressing potential algorithmic discrimination, including through its commercial surveillance rulemaking. Chair Khan, What do you see as the Commission's current role in addressing algorithmic discrimination, and what kind of authority might the Commission need in the future to stay ahead of advancements in technology?
Thanks, Congresswoman. And of course, any new statute that the Congress passes directing the FTC to take specific action here, we will follow. As a general matter, in the commercial surveillance rulemaking, we have issued a advance notice of proposed rulemaking that primarily asks questions. We got thousands of comments that our team has been digesting. The FTC also a decade ago launched something called the Every Community Initiative, where we specifically look at how particular communities might have been especially targeted by certain types of fraud, certain types of underserved communities, and so that work still continues. We also are charged specifically by Congress under the Equal Credit Opportunity Act to enforce that law and its prohibition on discrimination. And so through all of these statutory tools and authorities, we can act where we can. But I think this in particular is an area where greater clarity and direction from Congress is going to be key.
Very well, because I was going to ask whether you felt that that was sufficient. Let me thank you. Algorithmic discrimination can rear its ugly head in a multitude of settings beyond just automated critical decision-making processes, with impact consumer access to essential services, programs, or opportunities. Facial recognition technology is yet another tool powered by artificial intelligence, which has the serious potential for harm and bias, particularly for communities of color. The collection and use of biometric information in any instance, but particularly with respect to AI tools, is fraught with the potential for harmful outcomes and must be subject to rigorous oversight. The FTC's recent action against Rite Aid perfectly encapsulates these concerns. For years, Rite Aid used facial recognition technology to identify customers it deemed likely to engage in shoplifting and alerted store employees to their presence, subjecting customers to additional surveillance and unwanted searches. Though we all know these systems often fail to accurately identify people of varied gender, age, and racial backgrounds, Rite Aid never actually tested their system for accuracy. As a result, many Black, Asian, and Latino customers faced unnecessary additional surveillance and harassment from employees. While I was pleased to see that the FTC took action to defend shoppers from this kind of discrimination, I'm worried. I'm worried about the ongoing potential for harm from this kind of technology. Chair Khan, what can Congress and the FTC do moving forward to prevent this kind of discriminatory behavior in the future, and what can be learned from the Rite Aid case?
Thanks, Congresswoman. So as you noted, that was a case involving the use of facial recognition surveillance tools. There were very reckless practices that resulted in really horrible outcomes for underserved communities and for certain customers. As a general matter, I think you're right that as these algorithms and AI tools are being used to automate decision-making, there's a tremendous amount of opacity. We basically have these black box algorithms. We don't know what's going in them, and they're spitting out decisions that can be enormously consequential for people and determine who's getting access to housing, who's getting access to credit. Commissioner Holyoak earlier mentioned, de-banking or de-platforming. And these decisions about who's getting access to these essential services is going to be critical, and it can harm people on all sorts of dimensions, right? I mean, companies can discriminate against you because of your race. They can discriminate against you because you're a gun owner, because you go to church, right? The dimensions on which companies can discriminate could be quite significant, and I think it's something that we all need to wrap our heads around. Again, I think this is an area that the more Congress is able to legislate and give direction, be it to the FTC or others, that'll be essential. And we'll continue to use our tools as we can.
Very good. And I, again, thank you all for your service. With that, Mr. Chairman, I yield back.
Thank you. I thank the gentlelady. Now, I'll recognize Ms. Harshberger from the state of Tennessee. You're recognized for your 5 minutes of questioning.
Well, thank you, Mr. Chairman, and thank you to the witnesses for being here, and welcome to the new commissioners. We're glad to have you. You should have been here 2 years ago. We've had a lot of fun since then. Chair Khan, I scanned the PBM interim report, and, PBMs have failed to reimburse pharmacies adequately for years. I've been one of them for over 30 years, and It's led to pharmacy deserts. People can't find a pharmacy because they put the independents out of business. Inadequate reimbursement leads to another problem. Patients that have a nearby pharmacy are still unable to get their medications because certain PBM requirements on the drug or reimbursement on the drug is so low, they can't afford to keep the drug in stock. And so therefore, they can't dispense it because they lose medicine. My question to you is the FTC investigating these PBM practices that keep patients away from the drugs they need?
Thanks for the question, and I couldn't agree more. I mean, I've had the chance to hear from community pharmacists in Philadelphia and Kansas City. They all share a version of what you just said, which is that there are a whole set of practices that are squeezing them. Top of the list is this under-reimbursement issue. I mean, I've had pharmacists say, I'm basically auctioning off, customers I've had for decades.
You
because
absolutely
I can
are.
no
That's a good
longer
way to put it.
make money. I know my colleague, Commissioner Bedoya, has also heard from pharmacists across the country. So we recognize this is a major, major issue, especially for rural communities that depend on these pharmacies for essential health care. And so we were pleased to be able to share some of our interim findings from the orders we sent a couple of years ago, and we're going to continue to proceed with this inquiry. I should also note that our authority to conduct market studies is not, mutually exclusive with our ability to also conduct law enforcement. And so if in the course of this work, we identify practices that we believe violate the law, I will be supportive.
Well, that's my next question. Independent pharmacists and their patients, they're hurting. And that was my question. Will the FTC promptly begin enforcement action if it uncovers illegal practices waiting for final 6B study to be issued? So that's a yes. Commissioner Holyoak, I understand what you're saying. It's not comprehensive enough. I think the other two commissioners that resigned the study wasn't comprehensive enough. We talked to Chair Khan about helping her on the front end. Let us give you the questions. This is our area of expertise, mine and Representative Carter. We've dealt with this our whole lives, so we understand this issue. And Commissioner Bedoya, you talked to the AG in Tennessee and community pharmacists. This is a huge issue. I can help you in any way you want because I have the information. I've been asking somebody to look at them for over 25 years. And I understand what you're saying. I hope that it goes in depth. The rest, when you continue this, I can give you plenty of questions to ask. But Commissioner Bedoya, we talked a little bit a while ago in the interim report. Our previous conversation, you said there was a lot more left to do. And I want you to expand on what's left to study, and have you created new questions or concerns for what you've already found? They're pretty resistant about giving information. Am I correct in my assumption?
Thank you for that.
Yeah.
Thank you for that question, Congresswoman. Indeed, the report mentions on page 1 about the noncompliance with the orders that our staff is facing from these PBMs. And I'll note quickly, I personally am looking forward to, well, let me actually take a step back. I could not be more proud of this interim report. It marries rigorous quantitative analysis with actual documents we've obtained from these PBMs or pharmacists that, for example, completely change the terms of a pharmacy's agreement through a fax. And that fax, this is 2023, says if you do not reply via fax to this fax, expressing your objections, you will be auto-enrolled in these massive changes to your agreement.
Fax. That's a fax.
And so I think we're going to see more qualitative evidence, even more quantitative evidence, and I know our staff is going to press these entities to comply with the law.
Well, how are you going to force them to? Look, how resistant have they been about giving you information?
I'll put it this way, it's not every day that on page 1 of an FTC report it says these entities have failed to comply fully with this market study.
I wonder why. Well, talk to me later. No, I understand, and when you talk to community pharmacists and they get 2 contracts, one says, well, this is your rate if we're continuing to do, for example, the 340B program, and this is your rate if that goes away. Do you think that's a problem? Anybody? Anybody can answer that. I'll tell you the answer.
It sounds like a problem, yes.
Yes, it's the correct answer. It is a problem. I guess, well, let me just change gears. I've got 40, no, I'm overtime.
over.
Well, Gus, you just let me go on. Thank you, sir. I yield back.
I know better. I'm not going to cut you off, that's for sure. Okay, we'll recognize Ms. Trahan for her 5 minutes of questioning.
Thank you, Chair Bilirakis and Ranking Member Schakowsky, and thank you for the full slate of FTC commissioners for being here today. While I'm glad that this committee is continuing to work hard to protect consumers' privacy, I am shocked once again that Republican appropriators are suggesting that we hamstring the FTC by slashing its budget. It's important to remember that while Congress fails to pass legislation to rein in bad actors, regulators like the FTC are making a meaningful difference protecting consumers from harm. In the past year alone, the FTC has taken major actions against big tech's privacy abuses, online scammers, data brokers, junk fees, and pharmaceutical price gouging. Every dollar that Congress appropriates for the Commission results in $14 of benefits to our constituents by driving down inflationary prices and penalizing bad actors for breaking the law. And given the Commission's track record of delivering for the American consumer, it's embarrassing that we're even debating adequately funding the agency. Commissioner Bedoya, we are considering numerous proposals to protect children's privacy and safety online, an issue that I know you've worked exceptionally hard on. It's great that the FTC is updating the COPPA rule, and I support your proposals to require opt-ins to targeted advertising, stop platforms from retaliating against minors who exercise their privacy rights, and limit the use of minors' data to drive addictive features and notifications. Given the Supreme Court's recent decisions in Net Choice, Commissioner Bedoya, how do you believe that Congress and the Commission can best act to further protect children's safety and privacy online? And additionally, do you believe that greater research, transparency, and accountability into the content moderation and algorithmic amplification decisions made by online platforms would be helpful in that goal?
Thank you, Congresswoman. Thank you for your leadership on this. To answer that last question, absolutely yes. Let me offer two other thoughts. First, Net Choice is fundamentally about content moderation, and I think what we cannot forget is that if you look at the allegations of mental health harm against teens, that is just one source. Mm-hmm. You also have research suggesting that the sleep deprivation and anxiety that comes from extended use, quote unquote, designs that many people consider promoting addiction in the technology, that is another source. And then a final source is harassment that is made possible online. And I'm really proud that the Commission has voted out cases from our staff shutting down, making sure that there is a maximum of privacy settings that prevent strangers from harassing our teens. Commissioner Holyoak mentioned a terrific case came out today where teens were being falsely told that their peers wanted to know, have you had any surgeries? Are you straight? When in reality, it was the company that would then charge those teens money to try to find out who that was. And so the Commission feels strongly, I think I can say, that these companies shouldn't profit off of harassing teens online. The second item is expertise expansion. You look at the rosters of these companies, they don't just have lawyers, they don't just have economists, they don't just have technologists, they have psychologists and brain experts. Last year, I talked to a law clerk, she looked at just one of these companies, they had 140 PhDs in psychology and brain science. And so one thing we're moving to do with Chair Khan's support is to expand our roster of in-house expertise to include pediatricians, psychologists, and I hope to have that we're able to share more about that in the fall as we assemble this team.
Well, thank you for that, Commissioner Bedoya. As a mother of two young girls, I really appreciate the work. Chair Khan, as the FTC has been the most aggressive agency in terms of regulating tech platforms and products, I'd like to ask you about the Commission's effort to bring in technological expertise in-house. We just heard about the expansion, but I do think the technological expertise is important. In February 2023, the Commission stood up the Office of Technology, which, according to your budget request, now employs a wide range of experts who assist both the Bureaus of Competition and Consumer Protection in their law enforcement missions. Chair Khan, how has the Office of Technology helped the FTC hold technology companies accountable, and how does it work with the FTC's other branches to lend expertise to the agency's investigations and enforcement actions?
Thank you. I've been so thrilled that we've been able to stand up this office. We'd had previously some technologists, but putting this office together and being able to hire has been a game changer. We had heard we might face challenges when looking to hire because we can't compete with private sector salaries. But when we put out these postings, just within a week, we actually got 600 applications. I mean, there's just enormous hunger among technologists to come serve the public and make sure that these technologies are not harming people, be it kids, be it facilitating fraud. And so these technologists are on board. They're embedded across our investigative teams. They're working side by side, looking at the documents, looking under the hood, trying to figure out how are these algorithms working. And that's already paid off. I mean, it's making a difference in the lawsuits we filed, the counts we're able to include, and it's just really fantastic to be able to continue to build that expertise. I also really appreciate Commissioner Bedoya's encouragement for us to further think about other forms of expertise that are going to be needed as we continue this work.
Thank you. Yield back.
Gentlelady yields back. Now recognize, my pleasure to recognize my good friend from the great state of Michigan, Mr. John James. You're recognized for 5 minutes.
Thank you, Mr. Chairman. I've only been in this town for about a year and a half, and I've become convinced that a large proportion of this city's functions could be constitutionally and physically sent back to the states or streamlined with a good app, or eliminated altogether. We've become far too used to accepting mediocrity from our federal government. Every industry, I come from the automotive industry, we're expected to get more efficient, better, safer, faster, with less resources, though things become more complex. Air travel has gotten more complex, but more safe. And over the past 40 years, our medicine, our phones, everything we expect to be better than it was in the past without an exponential increase in cost. What's embarrassing is the fact that the federal government is the only place that is not expected to get more efficient and better with less resources over time. Folks in America have not lost faith in America. Folks in America have lost faith in Washington, D.C., because we have failed to live under the same standards of excellence and efficiency that they have. And so, for the private sector, those who do expect to get better over time, I just have a couple of questions based upon the feedback I've been getting from the innovators, the job creators, the business sector of how they have been experiencing the FTC. I'm hearing that your staff's engaged in following activities. One, issued guidance to Section 5 of the FTA Act, which at times runs contrary with decisions that are made in court cases involving the FTC. Two, issued hundreds of warning letters regarding companies, products, or income claims and threatened civil penalties, even in the absence of an administrative finding with respect to the companies. And three, used settlements and the threat of litigation to try to drive change in different industries. That sounds like bullying to me. That sounds like bullying the very sectors that are actually getting more efficient and doing more with less. Chairwoman Khan, after Chevron, will you commit to changing your practices, or do you plan on continuing doing business as usual?
Thanks, Congressman. Let me just say, first of all, the FTC staff is second to none, and I would disagree with any characterization or suggestion that they are mediocre. We are fortunate to have extraordinarily talented people who could be making multiple.
I classified this town in its wasteful spending as mediocre and expecting to have the same amount of money or higher spending when every other industry in the private sector is expected to do more with less. What is your commitment to efficiency, doing more with less, rather than complaining that you don't have the resources that you need to execute your job?
So we are day after day forced to be efficient. I mean, we have no choice. And one of the situations that we
Well, that's
face,
great to hear. So will this be a commitment on the record to change your ways rather than targeting or bullying in establishing standards unilaterally and a presumption of guilt with letters like the notice of penalty offenses concerning deceptive and unfair conduct around endorsements from every organization, from Abbott to Zulily, would you back away after Chevron and maybe have a presumption of innocence for most of these companies as they try to do their business?
So I don't believe that that Supreme Court decision affects the notice of penalty offense authority, which is really laid out in Section 5M1B of the FTC Act, and it's a very explicit authority that allows us to do this. As a general matter, of course, we're always going to do our work in accordance with any Supreme Court rulings that come down. One thing on your just efficiency point, our agency is smaller today than it was in the 1980s. The economy, meanwhile, has grown 16 times over. The mergers that are coming in the door are multiples of what they were decades ago. When
That's right. And decades ago, the company that I used to run, it was echelon smaller and more complicated and grew larger. That is the expectation, Ms. Khan, is that you have to do more with less of the American taxpayers' dollars while executing at a higher level. That is the expectation the American people have of themselves. That's the expectation they have of you. My next question, shifting gears to something that I've heard of everyone protecting our kids on social media. My West Point classmate Pat Ryan and I have Protecting Kids on Social Media Act I introduced. Unfortunately, there are hardly any rules governing what can be done with information of a child once it's collected. Would you agree and would you support Congress's efforts to act on data privacy to protect our children?
Yes, absolutely. I mean, as day after day, we see the real dangers of allowing companies to endlessly surveil kids, to harvest that data, to buy and sell it online. And through our enforcement track record, I think we've made clear that we will continue to be aggressive here. But of course, additional authority from Congress, including for the reasons Commissioner Slaughter laid out, given some of the outdated features of COPPA, is going to be critical.
Thank you, Mr. Chairman. I'm out of time.
Appreciate it. Thank you. Thank you for yielding back. Mr. Soto, you're recognized for 5 minutes of your questioning.
Thank you, Chairman, so much. You know, technology is emerging at an astounding rate. And when you look at artificial intelligence and e-commerce online, your charge to protect consumers is tougher than it ever has been. And you're doing that in the largest economy in the world. And, you know, I served in the state legislature for 10 years, and we used to refer to it as the Tallahassee two-step, where an agency's underfunded and then attacked for not doing their jobs. This is a budget hearing. We need to get you all the money that you need to be able to protect the American consumer, and I appreciate the work that you're doing. We recently passed out of this committee in a bipartisan fashion the Consumer Safety Technology Act. It also passed out of the House. One of the key provisions is to have an artificial intelligence pilot program that would allow you to consult with stakeholders and use AI to track trends in injuries involving consumer products, identifying consumer product hazards, monitoring the sale of recalled consumer products, identifying consumer products that do not meet specified importation requirements related to safety, and then produce a report. Chair Khan, how do you think artificial intelligence is being used right now to help be the cops on the beat, and how this bill may help you going forward, and how do you envision AI going forward and helping you do your job at the FTC?
Yeah, it's a good question. I mean, I think there's no doubt that we are trying to closely track how these AI tools could actually make our jobs easier and better, and try to figure out how might we be able to harness some of those advances, from, you know, improving our doc review process to making sure that our investigations are able to be more thorough. I think there's a lot of open questions about how we could actually benefit from some of these tools. I wouldn't say that right now we are at the stage where we're fully able to harness that potential, and partly that's because we haven't been able to make the critical investments that we would need in things like data storage and having, you know, greater cloud capacity in-house rather than having to contract externally for those types of things. So I think there could be a world in which we're able to get there, but it will require upfront investments, and we can only make those investments with continued support from Congress.
Commissioner Bedoya, what are your thoughts on the future of using AI to help protect consumers online and in the marketplace?
I appreciate that question, Congressman. There's one example I'd love to highlight for you. So you come from Florida. A lot of folks in Florida speak Spanish as a first language. Up until recently, the Commission could field complaints from consumers in English, sometimes in certain settings in Spanish, sometimes not. We recently acquired the ability through AI in part to automatically receive complaints in English translated from 13 languages, obviously including Spanish. And so that allows us to talk to 99% of the American population, or at least receive complaints from them that our staff can read in English using the power of AI translation. Is it perfect? No. Does it help consumers speak to us so that we can take it from there? Yes.
Thank you. Commissioner Slaughter, where do you envision artificial intelligence in the future helping the FTC to protect consumers?
Yeah, I will associate myself with the remarks of Chair Khan and Commissioner Bedoya. I think our focus on AI has been very respectful of the incredible power that it can provide in terms of new tools, new innovation, not only in private markets, but also for government players. And I think that, as Chair Khan noted, for us to really be able to utilize the benefits of the service, even as we police potential misuses or abuses in the market and are obviously vigilant about those ourselves, it's just really expensive, is the short version. And I will tell you that I think our focus right now is covering the costs that we have to do our job every day. And I would love to be in a universe where we can envision extra spending on new innovative tools. But I think we're not quite anywhere close to that from a budgetary perspective yet.
And Chair Khan, if we got you the funding for this, do you think it could make the agency more efficient, be able to cover more ground with the use of AI to assist you?
We're very keen to figure out how might we be able to deploy those tools, and we've been in touch with enforcers in other jurisdictions that are actually further ahead than we are in deploying technological expertise, not just in how they do their enforcement work, but also internally to further develop their institutional capabilities and capacities. And so those conversations have been very fruitful in trying to horizon scan and figure out what might that look like. And so if we were in the fortunate position of having those resources, it's absolutely something that we would benefit from.
Well, we know the crooks have AI, so we want to make sure the cops on the beat, all of you have those resources too, and I yield back.
Gentleman yields back. We'll recognize Mr. Fulcher for his 5 minutes of questioning.
Thank you, Mr. Chairman. And Chair Khan, my questions concern the recently finalized CARS rule, and if this is a duplicate, please forgive us, because we've got, some of us have competing committees today, okay? The FTC's website states the primary purpose of the CARS rule is to add truth and transparency to the car buying and leasing process. However, it's my understanding that your contention that this rule also sweeps in regulation of heavy truck dealers who sell business to business. Heavy-duty truck dealers retail cement mixers, garbage trucks, and the like. These vehicles cost hundreds of thousands of dollars and are not bought by consumers, as they are not consumer products. So my question is it fair? And is that accurate? Is that your intention? And is it fair for heavy-duty truck dealers to bear the regulatory costs of the CARS rule?
Thanks for the question. And I'll just note, we pursued this rule after a decade of enforcement and finding that unfortunately all too often people were getting.
Well, it's there, and so I'm asking the question, and I don't have much time, so please.
So as a general matter, the CARS rule applies. We're happy to look into whether it applies to some of these more specific types of vehicles, but the bread and butter is really regular auto dealers that are selling cars.
So you're not saying that this is absolutely going to encompass truck transactions?
I'd want to double check with our team.
Okay,
before.
thank you. The website for the FTC states that the new requirements mandated by the CARS are already business as usual for honest dealers. You've also stated that the purpose of the CARS rule is merely to stop bait-and-switch tactics and junk fees. Aside from the fact that bait-and-switch tactics and fees are for products that have no value are already illegal, I'm curious as to why the FTC never mentions the rest of the rule's numerous requirements. For example, record-keeping requirements that mandate a dealer capture and store for 2 years every text from every customer they sell a vehicle to, no matter how trivial or risk, being fined up to $51,744 per violation. So And there's other things, but to save time, wouldn't it make more sense to focus on pursuing the bad actors instead of making these broad mandates?
We've tried a strategy that just focused on the bad actors, and unfortunately, it wasn't enough. Thousands and thousands of Americans complain to us every year about getting tricked at the auto dealer. As you know, this is one of the biggest purchases people make. On this record-keeping issue, the proposed rule had actually contemplated requiring auto dealers to actually maintain greater records. In the final rule, we've really slimmed it down to just focus on instances in which auto dealers would want to be able to verify, right? What we don't want is
$24.1 billion and an additional 60 to 80 minutes to the car buying process. Is that slimming it down?
compared to what initially was proposed. But just to be clear, ultimately, we don't want auto dealers to be levied with an accusation and for them not to be able to substantiate their side of the story. And so the record-keeping requirements are focused on protecting the auto dealers to make sure that they're able to verify what their claims
Okay, I'm just going back. 24.1 billion is the estimate of the cost. 60, 80 minutes to the car buying process, and the mandate to store and capture 2 years of every text from a customer they sell a vehicle to, no matter what.
So as you know, a lot of rules both include costs but also benefits, and the benefits here we estimate would be $3.4 billion to the American public.
Okay, well, that's doesn't really match the $24.1 billion cost, so I might just point that out. You noted in last year's questions, for the record, that car prices have contributed significantly to inflation. But there's also inflationary impact of the regulatory costs that government imposes on small business. For example, a CARS rule acknowledges that it will cost over $1 billion. A study for the Center of Automotive Research points out the $24.1 billion cost. Every small business owner knows someone must pay for all the new disclosures, record keeping, and so on and so forth. So, Ms. Khan, I'm out of time, but I would just encourage you to take a look at this. The cost and the imposition on the dealers is making this very, very difficult. With that, Mr. Chairman, I yield back.
Thank you. Thank you. I appreciate it, Mr. Fulcher. Now I'll recognize Dr. Joyce from the great state of Pennsylvania, my fellow Pittsburgh Pirate fan.
Thank you. Apologies here. Can you hear me? Thank you. Thank you, Chairman Bilirakis, for allowing me to wave on to today's hearing. And thank you, Chair Khan and the commissioners for being with us here. As mentioned earlier in this hearing, Representative Duncan and I co-led a letter to the FTC, the USTR, and DOJ on the decision to abandon decades-long bipartisan trade policies proposed by the World Trade Organization. By abandoning these established international standards, we are abdicating our lead on the world stage and risking cross-border data flows in each and every sector, all under false guise of regulating big tech. It is clear from a FOIA recent request by the U.S. Chamber of Commerce that USTR coordinated these actions with left-leaning organizations such as Open Markets Institute, which Chairman Khan was previously the legal director. These questionable interactions are indicative of a type of closed-door dealings that are being used to pursue anti-digital trade policies throughout the Biden administration. Chair Khan, we risk cutting off every sector in the economy, from agriculture to medical diagnostics, from the international market by abandoning these trade policies. In fact, my district, Pennsylvania 13, had over $300 million in exports of digitally tradable services just in 2022 alone. Do you believe, Chair Khan, that by abandoning these provisions of established international standards, that there is potential of hurting American businesses and hurting my constituents?
Congressman, thanks for the question. The FTC was not involved in that decision relating to WTO digital rules, and so I would defer to USTR. As a general matter, when other agencies seek our expertise on consumer protection or privacy or competition, we are happy to provide it, and especially when certain trade agreements are implicating those issues, we think it's important to be able to share that expertise. But the specific decision you mentioned, I would defer to USTR because we were not involved.
So as I asked in my letter from January, is it appropriate for the FTC, along with USTR and DOJ, to conduct backroom deals on foreign trade policies without informing Congress?
So that doesn't characterize how the FTC operates. If other agencies seek our expertise, given the tremendous expertise of our staff on consumer protection, privacy, antitrust, we readily provide it. As you know, a lot of the trade discussions are non-public, and so that necessarily doesn't happen out in the open, but I would defer to USTR on any specific questions around that.
Well, did you, or to your knowledge, did USTR inform other government agencies, such as the State Department, that the U.S. was withdrawing from our proposed digital trade policies?
I'm not aware. I would defer to USTR.
Do you think that DOJ was made aware?
I wouldn't want to speak for DOJ, so I would defer to USTR.
So, in effect, these decisions appear to have been made in a vacuum. These decisions, as you said, are often under closed-door circumstances, and we in Congress are not made aware of how these decisions are made. This is quite concerning to me. Did you ask USTR to remove due process and consumer welfare safeguards from upcoming trade agreements?
Congressman, we share our expertise with USTR, and so when they seek our input on documents, and we want to make sure that we're not embedding in trade agreements policies that would undermine FTC enforcement, our ability to stop abuses of Americans' privacy, to be able to stop fraud, to be able to make sure illegal big tech monopolies are not misusing their power.
And if this involved removing due process?
Congressman, we follow due process in all of the FTC's work as the FTC Act, in accordance with the FTC Act, and we'll continue to do that.
Chair Khan, will you commit to disclosing all communications between Antitrust Division staff that were formerly employed by the American Economic Liberties Project or the Open Markets Institute and USTR staff that were formerly employed by either of these organizations?
Congressman, we're happy to look at your request and be able to engage however we can.
I think this is important information. I would really look forward to seeing your response to that. I think this information will allow us to have a better, trustworthy relationship with you and with your commissions. I thank you, the Chair, for allowing me to waive on to this important hearing, and I look forward, Chair Khan, to your response. Thank you, Mr. Chair, and I yield.
The gentleman yields. The Chair now recognizes the gentlelady from Iowa, Dr. Miller Meeks, for 5 minutes of questioning.
We're going to try it again. There you go. Thank you. And I thank the chair for allowing me to waive one to this committee hearing today. I was pleased to see the FTC launch an inquiry to investigate the role of vertically integrated PBMs back in June of 2022. I will also state that as a state senator in my first year in state senate in Iowa, I actually did my first bill on PBMs and transparency and rebates. The rebate part did not get through. I recognize the value of PBMs, but I think that we've been remiss in the vertical integration. You may be familiar with the graphic that is there, and what this is showing is the document that you have in requesting requests to the 6 largest PBMs. They control over 90% of prescriptions filled in the U.S. today. When I started Congress just in 2021, it was 70%, then it's 80%, and now it is over 90%. The FTC's interim report, which was just released this morning, highlights several concerning trends in the PBM space, including how this extremely concentrated market continues to allow middlemen to squeeze independent pharmacies and patients, all at the expense of access and affordability. Independent pharmacies, as the report notes, are subject to unfair and arbitrary contracts, which continue to contribute to the closure of these vital providers. Mr. Bedoya, thank you for testifying before the subcommittee today. You stated in the interim report that dominant pharmacy benefit managers can, or was stated in the report that they can hike the cost of drugs, including overcharging patients for cancer drugs, and that PBMs can squeeze independent pharmacies that many Americans, especially those in rural communities, depend on for essential care. And I've had several of those independent pharmacies recently close in my district. It is further noted that the FTC will continue to use all tools and authority to scrutinize dominant players across healthcare markets and ensure that Americans can access affordable healthcare. Do you believe vertical integration in healthcare has benefited patients?
Thank you, Congresswoman, for your concern. I share your concern. Of course, in certain circumstances, it has. What has jumped out to me from conversations with pharmacists across the country is how sometimes it backfires terribly. Let me give you 2 examples quickly, if I could. Met with a group of pharmacists from Louisiana. Hurricane came through. 2 parishes used to be served by roughly 24 pharmacists. Suddenly that was 5. 4 independents, 1 Walmart. People were walking into the independents with prescriptions for insulin and were being told, no, you have to go down the street to the chain pharmacy, which was under several feet of water. Another example, family walks in, a pharmacy, West Virginia, prescription for cancer medicine for their child. Pharmacist is told, looks at their screen, says, sorry, you have to go home. The PBM is telling me you have to go home and wait for your child's medicine
to be mailed
in the mail. Thankfully, that pharmacist worked with the insurance commissioner. They figured it out, but sometimes steering hurts people horribly, and I know that's something that staff spoke about in the report and something that I'm keenly concerned with.
So, do you believe it has lowered premiums, the cost of drugs, or the cost of care delivery?
That is a critical question. I would want to, that has economic stakes, and I'd want to, certainly I'm concerned that it has not, but you know, I need the support of staff to give you a firm answer.
In contrast to my experience in Iowa, where they had a year to be transparent with the data that we had requested, and it was just aggregate data on administrative fees, rebates, and administrative fees that were not passed on to the insurance companies, have PBMs and GPOs been complying with requests from the commission? And if not, what enforcement steps are you taking?
Page 1 of our interim report indicates that in many instances they have not fully complied, and I know this is of great concern to myself and something that we will be looking into.
Have you seen further consolidation in healthcare markets since launching the inquiry 2 years ago?
Certainly there have been attempts to consolidate. In my opening statement, I mentioned a couple of them. And when those proposed mergers have threatened to raise prices on consumers, degrade services for them, FTC hasn't hesitated to step in.
Well, I know that we're all very concerned about this. As I said, PBMs have a role and a valuable role that they play in prescription drugs, but there also is a lack of transparency and opaqueness and a lack of responsiveness by the PBMs to questions we would both ask at the state level and the federal level. And I would encourage you to continue into that and then hopefully respond to the vertical integration that's causing increased prices and less access. Thank you. With that, I yield back.
Gentlelady yields back. We appreciate you. Next, we'll have Ms. Kamick from the great state of Florida to ask questions. I didn't do that, buddy, just because you're a Georgia Bulldog. I didn't do that, and she's a Gator. Hey, I'm just being fair. You're not on the committee. All right, you're recognized for your 5 minutes of questioning, Ms. Kamick.
And it is because we are Gators. Go Gators. Thank you, Chairman Bilirakis, and thank you to our witnesses who are appearing before us today. As you can see, we are ready for football season, despite it being 109 degrees here in Washington, D.C. Ms. Khan, I'm going to start with you, and I apologize if these questions have been asked. I am in 3 competing hearings at the same time, so my apologies. Ms. Khan, according to the Office of Personnel Management, 87% of surveyed FTC employees agreed that senior agency officials maintained high standards of integrity and honesty. In 2021, this percentage plummeted to 53% and dropped further to 47% in 2022. This is all under your leadership. Why, under your leadership, has this number continued to decline?
Thanks, Congresswoman, and let me just say it's such an honor to serve alongside the talented and dedicated staff of the FTC. Those numbers have actually increased. The FTC this past year was among the 10 best places to work among mid-sized government agencies, and we'll continue to identify additional ways that we can make sure we're able to recruit and maintain the best talent. One source of complaint that we hear a lot about is pay. We know that we can't compete with private sector pay, but increasingly, we also can't compete with pay of other federal agencies like the Federal Reserve, the Consumer Financial Protection Bureau, the Securities and Exchange Commission. And so one way that, I think Congress could be really helpful is actually putting the FTC's pay scale on parity with the pay scale of the financial regulators.
So in 2021 and then in 2022, it dropped in half, right? And then you say it's coming back up. Is that because those that have been dissatisfied with your leadership have since left, rather than some radical turnaround happening at the agency? And I'll use that as a segue because in the same vein, your former colleague, Commissioner Christine Wilson, outlined concerns about your leadership in a 2023 Wall Street Journal editorial. And one example she used was the FTC challenge to Meta's acquisition of the virtual reality gaming company Within. Now, Ms. Wilson said, quote, "Consider the FTC's challenge to Meta's acquisition of Within, a virtual reality gaming company. Before joining the FTC, Ms. Khan, you, argued that Meta should be blocked from making any future acquisitions and wrote a report on the same issues as a congressional staffer. She would now sit as a purportedly impartial judge and decide whether Meta can acquire Within. Spurning due process considerations and federal ethics obligations, my Democratic colleagues on the commission affirmed Ms. Khan's decision not to recuse herself," end quote. Ms. Khan, you investigated Meta as counsel for the House Judiciary Committee as a congressional staffer, correct?
That's correct.
Now, would your remarks towards Meta and your investigative history against the company not be grounds for recusal from the case?
So the federal ethics laws require recusal if you have financial conflicts of interest. So if you own like huge amounts of Facebook stock, for example, or if you have close family ties to Facebook. I have neither of those. And so I followed the standard that was laid out that ultimately led me to conclude that I was not required to recuse. As a general matter, I think there's been a broad recognition that dominant technology companies have been able to get away with gobbling up a lot of their competitors and that we need to be more vigilant. And I've been really pleased at the FTC that we've been scrutinizing these dominant technology companies when they're making acquisitions that we have reason to believe might violate the law.
But as you laid out, you said you followed that to the letter of the law, right? That the ethics guidelines say that as long as you don't have any stocks, right, or financial obligations or considerations with that company, that makes it okay, despite the fact that you investigated them, were critical, derogatory even, in your work against Meta previously, and then now you're supposed to be impartial. I mean, by the standard of as long as you don't have financial obligations or an interest, I mean, heck, half of Congress, I mean, Speaker Emeritus Pelosi has financial ties and stocks with all these companies, and yet here we are making laws, which is why I think it should be prohibited that members of Congress own individual stocks of companies personally. But if you were faced with a similar case with a company that you had investigated as a staffer or made disparaging remarks about, in the future, would you consider recusing yourself? Because the optics are pretty damning. Don't you agree?
Congressman, I would just disagree with that characterization. I had certain expertise in certain markets, and I think that's what contributed to my being appointed in this role. And I think it would be really dangerous if we allowed companies that accumulate a lot of economic and political power to start picking and choosing which enforcers get to oversee them and which enforcers don't. And so I followed to the letter the legal standard that says if you have made up your mind entirely about the facts and the law, then you should recuse yourself. But if not, there's no requirement. I think we need to keep the bigger picture in mind as well.
Well, and I know my time has expired, but just yes or no, do you believe that the current concentrated app marketplace is fair for consumers and developers? Yes or no?
Congressman, certainly we've heard a lot of concerns about that concentration. There are lawsuits that have been filed, including by our colleagues at the Justice Department.
Thank you. Thank you, Mr. Chairman.
Thank you. I'll recognize Mr. Obanolti for his 5 minutes of questioning. I'm sorry, buddy. I have to follow the rules. I apologize.
This is a rare occurrence where I go before Buddy Carter. Thank you very much, Chair Khan, and the rest of the commissioners for being here today. I've enjoyed the testimony. Chair Khan, I want to thank you for some of the great work you're doing on trying to protect consumers from the malicious use of artificial intelligence. As you know, I'm the chair of the House Artificial Intelligence Task Force, and we have been working on putting in place a regulatory framework that will guard against some of those same harms. I know you and I have had a number of discussions on this topic, and I think some of the work you're doing is wonderful. I wonder, though, that sometimes we need to do a better job of educating the public about the fact that AI is largely regulated with respects to its malicious use. I mean, you make a great point in some of the testimony that you've given that AI is a tool and we regulate outcomes. And so that's why the FTC has the authority to regulate, for example, the impersonation of individuals and businesses, which is some of the actions you've taken recently. The use of AI to impersonate someone for the purpose of deception and theft is already illegal. It doesn't matter if you use AI or something else to do it, and that's why the FTC is empowered to stop it, and I'm glad you are. Recently, there have been a string of Supreme Court decisions that have made it abundantly clear that the court is reining back the ability of agencies to exercise authority that wasn't expressly delegated to them by Congress. And I'm sure that this is going to become an issue in a larger sense in the future, particularly with respect to AI because it's so new. So can you tell me, where do you think the FTC lacks authority to go after the malicious use of AI, and what more authority do you think you need?
Thanks, Congressman. I mean, this is a critical issue, and I think it implicates the FTC, but implicates a whole set of agencies, since the way that AI is impacting the public is just so multidimensional. You're right that there have been a whole string of Supreme Court decisions that could limit the authority of agencies like the FTC, and so we're following all of that closely. I think as a general rule of thumb, the more Congress legislates and the more Congress legislates very clearly, the better things will be. And so we would encourage the continued efforts by this committee and others to make sure that that type of legislation, especially addressing some of these new technologies, are absolutely critical. The FTC Act does ban unfair methods of competition and unfair deceptive acts or practices. And I've been very clear that I don't believe there is an AI exemption from those laws. And so if companies are using AI or algorithms to engage in price fixing, for example, or using AI to deceive the public, I believe our authorities would still cover that. But you're absolutely right that in the current environment, again, the more Congress is legislating and the more Congress is legislating supremely clearly, the better off we all will be.
Right. Well, let me just encourage you, let's work together on this. I mean, I think we're all on the same team here in our efforts to try and protect consumers against the malicious use of AI. And I don't want that conversation to devolve into an argument about who has authority to do what. So to the extent that you want authority to do something that you might not have, please come and ask us. To the extent that you discover things that require congressional action or legislation, please come tell us, and let's get that done together. It's ironic. This is the second time today I've had this discussion. Earlier today, we had a hearing with FCC Chair Rosenworcel, in which I had exactly the same discussion with her, because there's this issue of the use of AI in political ads, and no one can decide if it's the FCC that has authority, the FEC. And to everyone, I say, we're all on the same team here. Let's sit down and let's try and get the problem solved.
I really appreciate that and look forward to working together on it.
Excellent. A separate topic, a question for you, Chair Khan. You're, I'm sure, familiar with the section of the Magnuson-Moss Act that requires the Commission to provide Congress with a 30-day notice of proposed rulemaking to provide for congressional input, which I think is an important part of the open dialogue that we have between the branches of government. Do you have a notice, a proposed rulemaking that you think will be coming up soon?
Is the question, are we planning to issue an ANPRM in the next 30 days?
Well, in particularly the commercial surveillance rulemaking that you've been considering.
So we're not able to publicly disclose non-public deliberative process, but we, across the board, will be very careful to follow to the T the requirements of Section 18 under the FTC Act.
How many of those notice of proposed rulemakings has the Commission issued?
So under MAG-MOS, there have been a few rules that we've issued. One is the impersonator rule that you mentioned. There's another one that would take on this epidemic of fake reviews online, which can really pollute the online ecosystem and make it difficult for people to comparison shop. We have other rules that would be, going after similar types of deceptive or unfair conduct online. And so across the board, we've been very careful to follow the special procedures laid out in Section 18.
Okay, well, I'm out of time, but I just want to encourage you, this is an important part of our partnership, is giving us the notice when you're going to do something, which allows us some time to give us, for us to give you our input. So please be conscientious about that.
Absolutely.
All right, thank you very much. I yield back,
you.
Mr. Chairman.
Thank you, I appreciate it very much. Next, we'll hear from a gentleman from Georgia, Mr. Buddy Carter, for his 5 minutes of questioning.
Thank you, Mr. Chair, for allowing me to waive on this committee, and thank y'all for being here, and thank you for the interim report that was released this morning about PBMs and the impact they have on independent pharmacies. I believe that's the focus of the report, and I appreciate it. I became a member of Congress 9.5 years ago. The first thing I did when I got here was to go to the FTC and ask them to look at the vertical integration that exists within the drug pricing chain. 2 years ago, you did that, and I want to thank y'all for that. Now, Chair Khan, can you share very quickly what the FTC has discovered with these PBMs practices and their impact on pharmacies, on doctors, on patients, on payers?
Thanks, Congressman, and thanks so much for all of your encouragement and support of the FTC as we've endeavored to scrutinize what, as you know, is an extremely opaque part of the market. So the report lays out that there's been a continued trend of vertical integration as well as horizontal concentration, that the handful of larger PBMs have increased their share of the prescription drug market. We lay out in the report a lot of the concerns we've heard from independent pharmacies, which range from chronic under-reimbursement to steering, to arbitrary auditing, to all sorts of practices that I think at the end of the day to pharmacists make them feel like they can't get a fair shake. I mean, what I often hear from community pharmacists is they're serving their communities depend on them, but their ability to survive on the marketplace is subject to the whims of these actors that they increasingly find themselves competing with.
And is it true, and I don't mean to interrupt you, but is it true that we're losing about one pharmacy every day now? We're on pace this year to lose one independent pharmacy every day.
Yeah, we lay out in the report what some of those declines have looked like.
And I might point out that, whether you're Republican, a Democrat, or independent, we all want the same thing. We want accessible, affordable, quality health care. Pharmacists are the most accessible health care professionals in America. If one pharmacy every day is closing, accessibility to health care is going to be impacted. Mr. Bedoya, earlier we were talking about steering. I don't want to put words in your mouth, but did I understand you to say that there were some instances where steering was beneficial? Can you?
No, sir. I was responding to the part of the question that was a broad question: is vertical integration good in healthcare? And I said certainly in some instances it has been. I used to be part of a vertically integrated healthcare provider. I like that, right? I did not say, I'm not aware of instances of steering that I have found beneficial, although obviously I haven't studied this as much carefully as...
Chair Khan, have you seen instances of steering, of patient steering?
So the report does lay out instances where we've seen that. There's also been research suggesting that not only is this steering happening, but this steering is actually inflating drug prices and drug costs. And, 2 decades ago, there was a view that this vertical integration could actually lower costs of drugs and healthcare overall. And I think 2 decades on, we're having to take a clear look and try to see, was that assumption accurate, or have things actually become more expensive through some of these conflicts of interest?
And just for the record, in this committee, in the Energy and Commerce Committee, we have had a member meeting with the CBO, and I've asked them, not only just in pharmacy, but in healthcare in general, give me one example of where consolidation in healthcare has saved money. And they have not been able to give me one yet. I think that speaks for itself. Commissioner Holyoak, I wanted to ask you, I know that you and I have spoken, and I just want to ask you, are you supportive of the FTC's 6B study into the inquiry into the PBMs?
Absolutely, but I am supportive of a comprehensive study. I don't believe that this report, it does a adequate job of comprehensively looking at the industry, of understanding the competitive markets here and all of the players in that system. I don't think it does an adequate job at all looking at it doesn't do any job at looking at the economics.
So you voted against the release of the study?
Correct.
But I want to make sure we all understand that you're not in favor of PBMs and you're not saying, I'll let you explain. I'll let you explain your vote.
Oh, absolutely. And I'll step back for a second and talk about when I was Solicitor General in Utah, I was in favor of a lawsuit that we brought against PBMs because I was very concerned. We were concerned about some of their practices and their pricing, and particularly whether they were, in that instance, whether they were misrepresenting prices and savings to payers. And so I think I'm very supportive of a study that actually looks at the business model, that uncovers what is happening here, that can shed some light into some of these practices.
Again, and I'm running out of time, I don't want to put words in your mouth, but I just want to make sure we understand that your vote in no way indicates that you think that PBMs are helping the healthcare system.
My vote is because I don't think that this study is accurate. I
Okay.
am committed to a full, comprehensive study of PBMs.
Right.
And so that we can fully, objectively evaluate this industry and understand their business models. And without that, without a comprehensive study, we can't take any.
Okay. Well, I don't want us to let perfect get in the way of very good, and I want to thank you for this. And this is the interim report. The final report hopefully will be forthcoming, and I hope that we can get a more comprehensive, if you will, report. I cannot stress to you how important this, folks. I was a pharmacist for 40 years. I'm the one who had to go to the counter and tell the patient how much the medication was. I'm the one who had to do that. People can't afford their medications. They're getting ripped off. This has got to be busted up. No insurance company should own a PBM. No PBM should own a pharmacy. Period.
I share your concerns, Congressman, with better understanding this, and I am fully committed to ensuring that the Commission continues its work here and provides a fully comprehensive study.
Chair Khan, any?
I would just say, Congressman, to the extent that you have concerns about vertical integration, I mean, that's something that antitrust enforcers may be able to address through litigation, but it takes a long time, and bills that are clearly decoupling in those ways could be the most efficient way to potentially.
And I agree, we've got a big role to play in Congress, but when you say it takes time, one pharmacy every day is closing. Accessibility to health care is decreasing in this country.
Yeah, I couldn't agree more. There's enormous urgency here, and that's why we thought better to provide the public with the information we have already today, rather than, as you said, let the perfect be the enemy.
I apologize, Mr. Chair.
No,
Thank you
hey,
very
listen,
much.
just
I yield back.
don't forget that I give you that extra time.
I won't.
All right, appreciate it. You'll pay me back one day. All right, I had a question, but I think we've gone long enough. I appreciate y'all so very much for being here, and thanks for your patience. Thanks for the audience's patience as well. I thought it was a very productive hearing. So I ask unanimous consent to insert in the record the documents included on the staff hearing documents list. Without objection, that will be so ordered. I remind members that they have 10 legislative days to submit questions for the record. I ask the witnesses to respond to the questions promptly. Members should submit their questions by the close of business on July 23rd. Without objection, the subcommittee is adjourned. Thank you.
Let's get lunch.
Thank you again for being here. I look forward to speaking to you.
Let's do it.
Okay,
Yes,
we will.
absolutely.
Thank you
Thank
very
you,
much for
Congressman.
being here.
I hope I was clear about what I was saying.
You were.
He is. Thank you for hydrating these.
Not to re-up to that.